Interim order past years shall continue.
May I please, Your Lordship? My Lord, I beg to mention item number 4, Lordship. I am for the petitioner. I have taken consent from the other side, Lordship. In this case, my Lord, we are
4.
Lordship. We are supposed to take instruction from our client whether a compensation has been received or not. But my Lord, instruction is not complete because there is a 90 petitioner. All of them we are not unable to contact, Lordship. Further 10 days time is required, Lordship. I have taken consent from the other side.
Mr.
D. Goel, Lordship.
D. Goel and counsel for the petitioner has submitted that he has not received instructions from all the petitioners as to whether compensation amounts have been received by each of them. And in order to obtain the complete instructions, he has sought listing of the case after 2 weeks. It is submitted that consent has been taken from the learned counsel for the respondents to make the prayer. The prayer is allowed. List the case after 2 weeks. Only 2 weeks by hours.
Highly Lordship.
May I please, Your Lordship? Lordship, I beg to mention for listing a WPC for orders on 1811, Lordship.
Not 18. 18, no. What is the subject matter?
Lordship, the case is relating to land grabbing.
Land?
Grabbing.
22nd month, did you?
22nd.
22nd.
Your Lordship, I like to beg the item number 2. As my senior is out of station, I would like to adjourn the matter and kindly fix the date.
Then this is to be released from part third. This court is not likely to sit in a single bench. Mr.
M.M. Kashyap, Your Honor.
M.M. Kashyap, learned counsel, I pay him court. Mr. M.K. Chaudhary, learned senior counsel for the petitioners, has submitted that leading counsel, Mr. Chaudhary, is out of station on personal ground and has thus sought for listing of the case on another date. Mr. A. Borgotogi, learned pending counsel, NF Railway. H. Sharma, learned additional senior government advocate, 1 and 2, and Mr. H. Sharma, learned additional senior government advocate for the respondent number 4, 5, and 6 are valid. In view of the prayer made on behalf of the petitioner, with the consent of the learned counsel for the respondents, the matter stands adjourned for 2 weeks. And the matter is not to be, the case is not to be considered as part third, and it is relieved from part third.
Much obliged, Your Honor.
Your Lordship, I beg to mention WPC number 6622 of 2023 for listing.
For what?
For listing the matter.
What is the subject matter?
It's this case about land acquisition.
Orders column.
Pardon, Lordship.
Orders column.
On admission matters.
Read it. Hearing data? No hearing data.
For withdrawal, item number 21.
May I please, Your Lordship? Your Lordship, as per client's instruction, I'm praying to withdraw this petition.
Mr.
R. Karim.
R. Karim, learned counsel for the petitioners, has submitted, on instruction, that the petitioners do not want to pursue this petition. First of Mr. H. Sharma, learned additional senior government advocate for the respondent number 1, 2, and 3 is present. First of, in view of the above submission made by Mr. Karim, learned counsel for the petitioners, this petition stands dismissed on withdrawal.
Obliged.
Daily this for motion, item number 1.
Hey, RTI Act comes on.
May I please, Your Lordship, the matter may be possible for timing.
I have heard you.
Believe the law point is to be decided. Only the legality of section 18.
Your judgment I have perused. That was a direct complaint.
Absolutely.
direct complaint before the state commission
Yes.
after his RTI application.
Yes, sir.
He did not come through first appeal and second appeal route.
Absolutely. That is what the mandate of section 18 says, Lord.
Hmm,
That is what has been elaborated by this Honorable Supreme Court.
hmm.
That 18 and 19 are two different distinctive
Yes, but
remedies.
the procedure under 19 is different than
It's an
procedure under 18.
Yes, sir.
And section 18 says about any person. It includes a complainant. It includes an second appellant also. Second appeal appellant also. I don't think that because a decision is an authority what it decides, and it is about uh, on the facts of the case.
Lordship,
Yes, Mr.
It appears from the petition submitted by the petitioner that it is not an application under section 18. So it is open for the petitioner to submit an application in accordance with matter if.
No, he has specific allegation
No,
that
allegation is
quoting the provision is not a
Madam.
sine qua non.
My lord,
But if the ingredients are fulfilled,
my lord, it is for the my lord state commission to take a decision on this particular petition, my lord.
Yes.
Whether it can be entertained under section 18 or not, my lord. So it is open. for
in
the
my view,
state
it
commission.
appears to be a complaint.
My lord, my lord.
Clear
And
case that
it-
misleading, not related to my RTI petition.
my lord.
Kindly take necessary action.
My lord, under section, if.
It is page 34.
My lord.
His averments are clear.
My lord. So.
Now, if the power is there, source is available,
My lord,
and an application is filed,
my lord. So my submission is that it is open for the state commission to treat this petition. It is open for the state commission to treat this petition under section 18(3) and to proceed and to take a decision on the matter without expressing any opinion of the merit of the
no
case. my
merit
lord.
of the case.
My lord,
I am saying that he has made an allegation that the information supplied to him
it
is
and wrong.
misleading and not
My lord.
complete.
And lordship, I record my submission that application has already been transferred to the under section 6(3), so it is not misleading. That is only my submission, lordship. I recorded.
6(3).
6(3), my lord.
Where is
So that-
6(3)?
That is only my submission, lordship,
6(3) is at the initial stage.
initial stage. So that is transferred, my lord. So also only record my only that submission, legal
We'll
submission.
record the facts.
My
We'll
lord.
record the facts.
My lord, my lord.
We'll do the whatever is averred, what is it reflecting from the records.
My lord, my
We'll
lord.
do.
And lordship, page 21, that person, that petition itself says that it is required to be transferred under section 6(3). Accordingly, we have transferred the petition to the, my lord, principal secretary transferred the petition to the competent authority, my lord, to furnish the. That is only my submission. And it is open for the state commission to proceed in accordance with law, my lord.
Hey, down in RTI.
May I submit just one point also? What the Supreme Court has said in both one judgment and that judgment and another judgment in recently, that section 18 has a supervisory power. It's the nature of the section 18 is supervisory. So the question would be before this honorable court, can it be used or applied for non-compliance of the order? Because order of the Supreme Court is of the full bench of the Supreme Court. I'll just place it.
Then section 18 will be odious and redundant if your submission is accepted.
That is
And that result will be that court will be the executing court if your submission is accepted. There is no other forum.
absolutely.
An applicant will exhaust about 2 years' time. And after that, a teethless commission. And 18
But that is
will
what
be redundant.
that is how it has been read to the law lordship by the Honorable Supreme Court. It is judgment of full bench. Paragraph 10, Lord, which reiterates the finding of
Very nature of power. Hereditary license, so SSC to license.
2011.
Just a minute.
Yes, sir.
Madam, please take your seat. Okay. The petitioner has approached this court seeking to invoke the extraordinary and discretionary jurisdiction of this court under Article 226 of the Constitution of India, contending inaction on the part of the Assam Information Commission in the matter of taking cognizance of a complaint stated to have been filed, stated to have been filed by the petitioner before it on 21/05/2024. Full stop. The petitioner, the petitioner has claimed that he belongs to the scheduled tribe. Is scheduled tribe order 1952 the option? Chakma, which is recognized as a scheduled tribe in the district of Karbi Anglong, Assam, under the Constitution Scheduled Tribes Hills Order 1950. Full stop. To substantiate such fact, the petitioner has annexed a tribe certificate issued by the Office of the Deputy Commissioner, Karbi Anglong, on 13/12/2017 as Annexa 1 to the writ petition. Full stop. The petitioner has stated that in order to obtain information as regards allotment of forest land under the provisions of the land policy frame. You please take your seat. I'll go through it.
Okay.
You submit it on.
Yeah.
Under the provisions of the land policy framed by the government of Assam and the scheduled tribes and other scheduled tribes and other traditional forest dwellers within bracket recognition of forest rights bracket close Act 2006. Recognition of forest rights into bracket. He submitted an application on 22/12/2021. Before the Chief Executive Officer, Karbi Anglong Autonomous Council, Difu. Seeking information, seeking certain information. Also, when the said application was not responded to, the petitioner submitted another representation on 16/2/2022 before the same authority, but the said application was not responded to. Said application 2 was not responded to. Postal. Para. Thereafter, the petitioner and then submitted an application under Section 6 of the Right to Information Act 2005, within brackets, the RTI Act. Before the Public Information Officer, Karbi Anglong Autonomous Council, Difu, on 6/10/2022, seeking the following information, page 21, A to A. In the said, in the said application, the petitioner requested for information at the earliest, and further stated that if the information requested information were not available in the office, then the application was to be transferred under Section 6 within bracket 3 of the RTI Act to the Public Information Officer to the concerned public information officer with intimation to the applicant. Full stop. Para. Software, when the petitioner did not get any reply from the PIO of the Karbi Anglong Autonomous Council, and the petitioner did not had neither received any reply nor any information as sought for by him under the RTI Act, he preferred an appeal before the first appellate authority. O/O, the Karbi Anglong Autonomous Council, DIFU, on 3/1/2023. First of the said appeal was received by the office of the first appellate authority. First, after waiting for a reply, after waiting for a reply from the first appellate authority, the petitioner did not receive any response. He stated to have approached the, what is his name? Information Commissioner or Chief Information Commissioner?
State Information,
Huh?
some State Information Commission. That is the
Stated to have approached the Assam State Information Commission by preferring an appeal under Section 19 of the RTI Act on 24/3/2023, highlighting the approaches he had made before the public information officer and the first appellate authority. First, on receipt of the appeal, second appeal, under the provisions of the RTI Act 2005, the registrar, Assam Information Commission, issued notices to the State Public Information Officer, O/O, the Karbi Anglong Autonomous Council, seeking his presence at the hearing, along with all the relevant records at the hearing scheduled on 7/2/2024. With the information that the State Assam Information Commission had decided to hear the matter. Full stop. The SPR IO was directed to submit a written statement mentioning the date of receipt of the application under the RTI and the date of furnishing the sought for information to the applicant, that is the petitioner, if he had already furnished the information. Full stop. The SPA was further informed that if the sought for information was not furnished to the applicant, then the written statement should explain as to why penalty under Section 20 of the RTI Act shall not be imposed on him for his failure to furnish the sought for information within the stipulated time period. Full stop. The SPA was further informed that if the request for information was rejected under Section 7 within bracket 1, then his written statement should indicate the date of receipt of the application under the RTI application and the date of rejection by him, giving reasons for such rejection. Reasons for such rejection. Full stop. Subpara. When? Okay. On on 7/2. Something is wrong. Okay. On 7/2/2024. In the hearing, on 7/2/2024, before the commission, I got start with commission. The petitioner was represented by a legal aid counsel with a letter of authorization from the Assam State Legal Services Authority to represent the petitioner in the hearing. Full stop. The SPIO O/O, the Principal Secretary KAAC, was not present at the time of that hearing, nor any written statement or any petition stating reason for his absence was submitted. Full stop. The commission, on tracking the postal consignment, had found that notice from the commission was duly served upon the SPIO O/O, the Principal Secretary KAAC DFU, on 20/01/2024. Post. Viewing such absence, the commission directed the SPIO to furnish reasons why necessary action should not be initiated against him for violation, for non-compliance of the direction made in the notice, and such explanation should reach the commission within 10 days of receipt of the order passed post op. Software. In the order, after the hearing, the commission had passed an order on 8/2/2024. এইটো এই আগৰ পেৰাটো প্ৰথমতে লিখিব। আগৰ পেৰাটো সাব পেৰাটো প্ৰথমতে লিখিব। First. In the order, comma, the commission noted that the petitioner sought information under 6 number of heads and the information sought for pertain to allotment and settlement of forest land for the scheduled tribe villages under the provision of the land policy framed by the government of Assam and the State Act 2006. So stop. At the hearing, comma, the representative of the petitioner, the legal aid counsel appearing on behalf of the petitioner, submitted that no reply whatsoever to the RTI application was furnished by the SPIO and in view of no response by the first appellate authority, the petitioner had to prefer the second appeal. Post. The on the basis of the commission had gone on to observe as under. It had gone on to observe in its order dated 8/2/2024, comma, had gone on to observe as under. Page 28, 29, A to A. No. The commission had observed that the manner in which the public authority had acted was in disobedience of the provisions of the RTI Act. First off, taking note of the facts and circumstances of the case, comma, the commission had gone on to observe the commission in its order dated 8/2/2024 had directed the public authority to furnish reply to the petitioner by registered post or email within a period of 20 days of receipt of the said order. Post op. The commission further observed that the second appeal would be heard once again on 5/3/2024. And the superintendent of police Karbi Anglong was requested to ensure the physical presence of the public authority concerned on 5/3/2024 during the hearing of the second appeal. First off. para. The hearing on the second appeal, which was registered as case number 3304-23 stroke is 22 or 32 stroke within bracket KAN bracket close stroke 4 stroke 2023 took place again on was held again on 5/3/2024. Post stop. In the said hearing, the public authority was represented by the in charge principal secretary KAAC, accompanied by the Land Standing Council KAAC. Full stop. Insofar as the explanation sought for by the Commission regarding absence of the SPIO during the last hearing held on 7/2/2024, the SPIO submitted an explanation to the effect that the petitioner as an applicant had filed several RTI applications and the replies were given in respect of some of the earlier applications. The SPO further stated that the order dated 7/2/2024 and the case under reference were not brought to their notice, and the office was under the impression that the case was already heard and replied. The Commission found the explanation provided by the SPIO to be a lame one. During the hearing, the SPIO and the Land Standing Council KAC had prayed before the Commission for granting 10 days time to reply to the RTI application of the petitioner. In view of such submission made by the SPIO and the Land Standing Council KAAC, the Commission had disposed of the second appeal with the following observation and direction. Page 31, A to A. After disposal of the second appeal, by the order dated 6/3/2024. A commission disposal of the second appeal with the following of the by an order dated 6/3/2024 করে দিব। After disposal of the second appeal by the order dated 6/3/2024, the principal secretary, in charge AAAC had addressed a letter dated 13/3/2024 to the petitioner, purportedly furnishing the information sought for by the petitioner in his RTI application. The contents of which read as under page 32, B to P. Para on receipt of the number to on receipt of on receipt of the letter dated 13/3/2024 from the principal secretary in charge, KAAC, right, letter dated 13/3/2024. I have a question. The petitioner approached the commission once again by submitting a letter, by submitting a complaint on 21/5/2024. Stating the fact that he had received an email on 13/3/2024 and subsequently, the information via and subsequently, the information by post from the SPIO O/O, the principal secretary, KAAC, post up. In his complaint, the petitioner had alleged that though some information was supplied to him, but he found the information supplied to him to be misleading and unrelated to his RTA application dated 6/10/2024. Post up. Along with his complaint, the petitioner submitted the photocopies of the information received by him on 13/3/2024 from the SPIO as annexer Roman 3 to the said complaint. Post up. With the aforesaid projections, the petitioner requested the commission to take necessary action against the principal secretary in charge SPIO O/O, principal secretary in charge Caribbean Autonomous Council Roman and SPIO O/O, principal secretary KAAC, under the right to information under the RTI Act for supplying wrong and misleading information and for willful disobedience and deliberate disrespect of the order dated 6/3/2024 of the commission passed in the second appeal, comma, case number 330423 stroke KAN bracket close stroke 4 stroke 2023. Post stop. Para. As the petitioner has preferred this petition, contending that despite receipt of the complaint dated 21/5/2024 by the Commission, on 31/5/2024. There was no consideration on the complaint, and hence the writ petition under Article 226 of the Constitution of India. Post stop. Heard Mr. B. Kishan, learned counsel for the petitioner. Is Forrest there? Mr. B.D. Deca,
Lordship, D deck,
B. Deca,
D
D. Deca, learned standing counsel, Assam Information Commission, for the respondent number 2, and Mr. J. Sutia, learned standing counsel, Karbi Anglong Autonomous Council, for the respondent number 3 and 4. Post stop. Para. Yes. Mr. Shen, learned counsel for the petitioner, has submitted that the commission is a statutory commission under the RTI Act. Post stop. In the case in hand, comma, the commission entertained a second appeal, and thereafter disposed of the second appeal by an order dated 6/3/2024, directing the SPIO to furnish the information to the petitioner via email stroke registered post without fail. Post stop. Such a direction came to be passed when, during the hearing held before the commission on 5/3/2024, the SPIO and the Learned Standing Council KAAC had made a prayer before the commission that the information be supplied. Information under the RTI Act would be supplied to the petitioner provided they were granted 10 days time. Post. He has further submitted that in the complaint dated 21/5/2024, the petitioner had categorically contended that the information supplied to him by the letter dated 13/3/2024 were misleading and not related to his RTA application dated 6/10/2024. Full stop. In order to substantiate such contention, the petitioner had also furnished the photocopies of the information he had received on 13/3/2024 from the SPIO post office. When a request has been made to take necessary action for supplying wrong and misleading information and for willful disobedience and deliberate disrespect of the direction passed in the order dated 6/3/2024, the commission should have acted under the provisions, should have treated the complaint under section 18 of the RTI Act, and thereafter should have proceeded to make an inquiry about the contentions made by the petitioner in his complaint dated 21/5/2024. Post. Yes, your judgment. Paragraph
10, Lordship.
starts with word
Paragraph 10, Lordship.
10,
Nature of the section.
manner of power. Then
What my contention is, before your Lordship, is that section 18 being the nature of section 18 being supervisory, will it be permissible in law to apply it for executing an order of the commission, Lords? That probably has to be.
what is supervisory? It can be related to Article 227.
Lordship.
That is also supervisory jurisdiction. When the courts under it
Lordship.
or the tribunals under it
Lordship.
does not act as per the provisions, then it can make any direction as permissible. And one of the thing is that when a jurisdiction is vested in a court or tribunal or an authority,
Yes.
the other one, the mandamus also, when a jurisdiction is vested or discretion is vested in a court, tribunal or authority, and that authority does not exercise that jurisdiction, then a citizen has a right or a person has a right to file a complaint. It has to come to a reasonable conclusion. It does not exercise its discretion. It has to exercise a discretion, either reject or that. But supervisory jurisdiction is that.
Lordship, that is in an original application when RTI is not
Okay.
information. That is what has been the.
Where it is said, mister, where you are trying to distinguish and trying to make the commission as a toothless one.
Lordship, that is the.
That is not, nowhere it is said,
There is no judgment.
none of the decisions.
Lordship,
Show me that 18 is completely barred and it should be treated as redundant if your submission is correct. Show me something.
What I'm submitting is once an order has been passed under section 19(3), can we route back to section 18 as in complaint, Lordship? That is the.
This is I am holding.
Lordship.
A number of high courts are holding.
we will oblige.
In fact, I am told that coordinated benches are holding.
We'll be obliged if that order comes.
I
We
think
have-
you are the counsel, you would know.
We haven't come across as maybe it's my.
Mr. Deka, Learned Standing Counsel, Assam Information Commission has submitted that the powers of the commission under section 19, under section 18, and under section 19 of the RTI Act are distinct
Lordship.
and separate, distinct. Full stop. The power under section 19 is an appellate power, whereas the power of the commission under section 18 is a supervisory one,
Lordship.
right?
That is what. Lordship.
That is one.
That is what.
You are
it is.
saying,
Yes, Lordship, that is.
full stop. What more? That it is barred.
Lordship. I'm saying, after order is disposed of by under section 19(3) in a second appeal, if that is not complied with by department, can that a complaint of non-compliance be treated under section 80?
So what will happen? Tell me.
Lordship, what?
Tell me the route thereafter.
Lordship, on the.
You
even
tell
on the-
me the route also.
Even on the last occasion, Lordship, the basis of we are not acting on non-compliance was that understanding of the commission and commission was that. However, Lordship, if you look in the other side,
Not tell me the route.
Lordship,
Tell me the route. Which one is the will be the route?
my humble submission, Lordship.
226 or 227?
Lordship, 226 will give a legal right is created on to the petitioner by the order, as he has no alternative and efficacious remedy. So, Lordship, in my humble submission, 226, he has to come, otherwise he will not have an
And
alternative.
High Court will assume the executing court's jurisdiction.
That is-
Tell me that in that line.
Lordship, not.
I am
Lordship,
wanting your submission.
I'm not submitting on that line, Lordship.
26 what will do? What the court will do? Tell me. Tell me. If your submission is that I'll direct the State Information Commission, KAAC, PIO to furnish the information, that will be a role of the executing court. Now, what is mandamus and what is certiorari? Certiorari simply quashes the order and it does not
Pass it directly.
pass further order. Directs the authority to revisit the order. Certiorari. Here it is not a case of certiorari. You have passed the order and they are alleging inaction. Now, then whether mandamus. Mandamus is what? When a citizen has a right and the tribunal, court or authority, if it is civil court, it is a different. A tribe or any authority under Article 12 or a public authority or a tribunal owes a duty. Now, see the wording of section 18 once again. See the word. What the word?
Powers and function of the Information Commission.
Yes. Read further.
Subject to the provisions of this act, it shall be duty.
Duty.
Yes, Lord.
Duty.
Subject to the provisions. of
What
this-
is, where is your duty? Sitting in action is your duty.
Lordship, it is, in my humble submission, not to be in
So
action.
tell me what is your exact submission? I will record
Lord-
because appellate jurisdiction and supervisory jurisdiction.
Lordship,
Then
My-
after an appeal is appellate's order in the second appeal is filed. Now
Yes.
what is the duty of the commission on receipt of a complaint. That is, I will record.
Instead of the complaint of non-compliance of the order of the commission.
Okay,
That order we are clutched because there's no provision which permits us to act on it.
okay. Mr. Deka has further submitted that after an appeal order in a second appeal preferred under section 19 of the RTI Act is passed by the commission, comma, and disposes of the second appeal, the petitioner, the commission has no power
No power as per.
no power to take cognizance of a complaint of such nature under section 18 of the RTI Act. This
of
is your submission
non-compliance of the order.
in support of his submissions, comma, Mr. Deka has referred to the decisions of the Honorable Supreme Court in Chief Information Commission and another versus State of Manipur and another, comma, 2011-15 SCC 1 and 2023-14 SCR. Likhibhan again. Kishan Sanjain versus Union of India and others, comma, 2023-14 SCR 477 colon 223 INSC 915. Or it SCC likha ase nahi? SCC likha nahi, no? Okay. First off. Yes, your regulation. Mr. Sutia, Learned Standing Council, KAAC, appearing for the respondent number 3 and 4, who are the SPIO in the case in hand,
That submitted.
has submitted that.
Under section 6(3) of the RTI Act, my lord, the application submitted by the petitioner was forwarded to the.
Okay. The application submitted by the petitioner under section 6 of the RTI Act was forwarded to the appropriate authority under
Chief
section
Conservator of
6,
Forest.
under subsection 3 of section 6 of the RTI Act.
Act.
Where is that?
It is the page 32 to the Chief Conservator of Forest, Council Head of Department Forest, Karbi Anglong Autonomous Council.
With any information to the applicant?
No, so it is for the petitioner that.
No. You are forwarding. Let us see the provision.
My lord.
Let us see the
My-
provision,
my-
Mr.
My lord.
Established from record. 60 is what? And inform the
When an
applicant
application
immediately
is
about
made
such
with
transfer.
public authority requesting for an information which is held by another public authority, the subject matter of which is more closely connected with the functions of another public authority, the public authority to which such application is made shall transfer the application or such part as it may appropriate to that particular authority.
And read further. The public authority to which such application is made shall transfer the application or such part of
Inform the
so-and-so
applicant-
and inform the applicant immediately about the transfer. Where is that? Where is that?
My lord, petitioner admitted that that application was mailed to the petitioner.
Which one?
That application, that, my lord,
Where is admission? Where is the admission?
My lord, that is, my lord, annexer 10, page 32.
Hmm.
Petitioner received it, it is addressed to the petitioner, my lord.
received your petition
My lord, it is
dated,
addressed to
you are replying in 2024
my lord,
that received your petition on 20/04/2022
my lord.
and it was forwarded to the Chief Information Conservator dated 85 for
18/5/2022.
submission of his views and comment in this regard, copy
Madam.
and close.
Madam.
60 contemplates after reply inform about in 2024.
My lord, that is what is record
Complete.
subject, my lord. My lord,
Absolutely.
my lord. Whether it is, my lord, misleading, wrong, it is required to be decided by. the
That
state
I'm not
court.
commenting, Mr. Sutia. I'm not commenting on it.
My lord.
Misleading or this thing.
Or it is
I'm not
inadequate, or it is
Mr.
inadequate.
Sutia, I'm
My
not
lord.
complaining about anything.
My lord. But
That
lordship
I'll
observed-
not record.
But lordship observed that.
No, no, I'll not observe.
But-
I
No.
have made it
Mm.
clear. What he had alleged in the complaint, I have noted.
But-
I have not given my views,
My lord,
Mr.
my lord,
Sutia.
My lord, it is- my lord.
I am only on
I
the
understand.
power under Section 18.
My lord, my lord.
And it has to be, if I hold that this is a complaint under Section 18,
My lord.
that inquiry has to be done by the commission and it has to reach its own decision.
My lord, my lord. I have,
I am not commenting on it.
so only my submission is that. lord,
My,
My lord, my lord.
my,
lord.
there is the ambit of
My lord.
a
I
read in the
understand.
nature of mandamus is also limited.
My lord, whatever is in the record, my lord, I am submitting only on the basis
Okay,
that it was, my lord,
has submitted that,
it was communicated to the.
has
petitioner.
submitted that after receipt of the original application of the petitioner
And
on
submitted, my lord.
24, this is 24,
One original application submitted to the chief executive member, that is the political head. So that is the important part, my lord, on our part. The application, he sought the application information about his application submitted to the political head of the council, my lord. not to the
Mr. Sutia,
No, only
Mr.
my lord,
No,
chief
Mr.
member.
Sutia, come to page 20.
Yes,
20. He was not concerned with that 20/04/2022.
my lord,
We are concerned with 6/10/2022.
my lord, my lord.
Am I making it clear?
My lord, my lord.
He said that he approached earlier to these authorities, but he started taking steps under the RTI Act from page 20 onwards. Where is that?
He has submitted, my lord, he sought the information about his application to the chief executive member. So that is the, my lord, that is, he submitted the application.
Come to page 21.
21,
Why,
my lord.
why you are trying to?
No, it is admitted, my lord, page, my lord, paragraph 1.
He
my
is
lord.
very clear about it.
Yes, my lord.
He is very clear about
My-
it.
No, it is.
I am not, if you want to make it longer,
No, only lordship address that the application submitted to the chief executive member. That word is there, my lord. If you may put that word only. When the
now
chief-
I'll hold adversely.
Lordship,
Hold adversely. If I'm not taking,
lordship,
I'm
yes,
taking,
yes,
not taking note of page 18,
my lord.
then it is
page
going to be bad on you. I'm not taking note of this page 18.
The page of 21, my lord, page 21.
Page 21 is public information officer.
No, page 21, my lord, second paragraph. Second, what is the case, my lord, contention? When did the said petition place in files before the honorable chief executive member? When did the petition receive in the office of the chief executive member? That is his contention. my lord. So I'm putting it that the chief executive member, he has submitted, so that is his petition. So we have.
I'm not commenting, Mr.
Yes, my lord.
Mr. I'm not commenting about the questions
Yes, my
and the
lord.
reply.
Yes, my lord, my lord, my lord,
Why you're
my lord,
unnecessarily taking
Yes,
me
my
to
lord.
that?
my lord. That is my
I'm
first
not
contention.
understanding actually.
My lord, that is my first contention. But as your lordships, my lord, that it is the regarding the legal provisions, my lord.
No, I am on that appearance of the chief executive, sorry, principal secretary before the commission and the standing council.
My lord,
And they undertook to supply whatever
whatever, my
they
lord.
submitted to the jurisdiction of the tribunal
My-
commission.
Commissioner. my
We are not into question number 1 and reply to question number
lord.
1.
So our contention.
We are not dealing.
My
If
lord,
you want to deal me,
no, no,
I'll
I'm
deal.
not, no, my lord, only my contention.
I'll deal there.
No, my lord, my contention is that
Despite my repeated,
only, na PS 32, that it was
I
communicated.
try to assuage you that I am not dealing with it.
Yes, my lord.
But still you are
I'm
insisting,
insisting.
then I'll hold it.
I'm not insisting. Then my second point is, my lord.
Yes,
pursuant,
please, on law.
Section 19(8).
Okay, no, on law you can.
RTI Act, my lord.
We are
RTI
not dealing with it.
RTI Act, Section 19(8). As the petitioner submitted his application under Section 19.
We are not concerned with these political masters.
Section 19.
Why
my
still
lord.
you are still going for political masters?
My lord. Like he filed the application, my lord, not us, my lord. So, my lord, Section 19(8), 8, my lord, subsection 8, and C, my lord. In its the first 7, the decision of the State Information Commission, as the case may be, shall be binding. So there is a procedure for imposing penalty under Section 19(8)(c).
19(8)
C.
C.
Impose any of the penalties provided under this act. So Section 20 is the provision for imposing the penalty. So the my submission, my lord, the State Information Commission is required to proceed if the information is inadequate, wrong, or misleading, then for imposing the penalty, not for giving the information, my lord. That has been held by the Honorable Supreme Court in that particular case, my lord, 2011 15 SCC 1. In that case, my lord, paragraph 32, my lord. That is the, my lord. I'm reading it, paragraph 32.
It starts with
In the facts, my lord. Now, it has been contended. Paragraph 31. 31, my lord. It has been
you are
contended.
holding SCC.
SCC, my lord.
He has handed me over something else. 31. In 31. Okay. We
Page
are
30, page 30 then. Yeah.
no, no. The
paragraph
paragraph starts
30.
with. Paragraph starts with.
It has been contended.
Okay.
It has been contended before us by the respondent that under Section 18 of the Act, the State Information Commission has no power to provide access to information which has been requested by any person, but which has been denied to him. The only order which can be passed by the Central Information Commission or the State Information Commission, as the case may be, under section is an order of penalty provided under Section 20. However, before such order is passed, the commission must be satisfied that the conduct of the information officer was not bona fide. The second, paragraph 32, we uphold the said contention and do not find any error in the impugned judgment of the High Court, whereby it has been held that the commissioner, while entertaining a complaint under Section 18 of the said Act, has no jurisdiction to pass an order providing for access to the information. So that is the distinctions made by the Supreme Court regarding 18 and 19, my lord.
Okay.
My lord, then the paragraph 42. And here, my lord, 41, my lord. No, not 41, my lord. 42. We are of the view that paragraph 37, my lord. Yeah, in the particular. We are of the view that Section 18 and 19 of the Act serve to different purposes and lay down to different procedures, and they provide to different remedies. One cannot be substantiated for the other.
Has submitted that in
2011 15 SCC
in
1.
Chief Information Commissioner and Supra
That's why you can read it.
2011-15 SCC 1.
That's
It has been clearly held that the Section 18 and Section 19 of the RTI Act serve two different purposes, and it has been laid down. It has laid and have laid down two different procedures, providing to different remedies. And first of it has been further held that one cannot be a substitute for the other. First of. And as such, first of, he has thus contended that the submission of a complaint of the nature which the petitioner has filed in the case in hand before the commission on 21/5/2024 is not an appropriate remedy.
It's not
The
an
remedy,
appropriate
about remedy
application.
now.
It's not an appropriate
It is
application.
further submitted that the subsection 8, under subsection 8 of section 19 of the RTI Act has vested the commission with the power to impose penalty under section 20. Full stop. Any about the remedy?
My lord, remedy,
Now
lordship,
nobody is submitting
my
about the
lord,
remedy.
my lord, remedy, my lord, lordship.
If the submission, I will hold.
My lord,
If the submission,
my submission, my lord.
counsel
My-
for the respondents
for-
are to be accepted.
For assisting the court, my lord, my submission is that for imposing penalty, my lord, the commission is required to
And,
make an inquiry.
Both of you are submitting
No, no,
that
both
this
of-
petition is not maintainable?
No, now my submission is that maintainable in the present form.
Hmm?
Maintainable in the present form.
He has further contended that the instant present petition is not maintainable in the present form.
Not repetition, but an application submitted before the commission.
Okay. And a complaint dated 21/5/2024 submitted before the commission is not maintainable in the present form. Full stop.
My lord, only to assist the court, my lord, that is by submission, my lord. As there is a provision for imposing penalty under section 19(8)(c), so that it is required to make an inquiry. To make an inquiry, the provision is under section 18, my lord.
He has further submitted that in order to impose penalty under
Section
subsection 8 of section 19,
and section 20
a procedure of inquiry,
is required to be made.
an inquiry is to be conducted by the commission, and it is for the said purpose.
Only
The provisions of section 18
can be
can be applied.
legal submission.
Full stop.
Can be invoked by.
Full stop.
May I not take 2 minutes of your lordship?
I have heard you enough.
I'll just refer to section 18 just once.
We have read enough and enough. How much? This is a read petition, so you will have the remedy of taking it to higher court.
Actually, we are not averse to information being accessed.
But you are not providing anything.
That-
So if I'll hold, if the submission of the learned counsel for the respondents are to be accepted, the petitioner will be denied of the fundamental right of under Article 219 1A.
That's,
I will hold now.
that's,
Okay. I have considered the submissions of the learned counsel for the parties and have gone through the decisions referred to by the learned counsel for the respondents. Close to. As the submissions of the learned counsel for the parties and to decide the issue. The কি করলো? Involved in this petition, it would be appropriate to refer to the provisions contained in section. It would be appropriate. It would be short likhable. It would be short likhable. RTI Act. First likho. 2000. The Right to Information Act has been enacted. For setting out a regime of right to information for citizens to secure access to information under the control of the public authorities, in order to promote transparency and accountability in the working of every public authority. Full stop. Under Section 3 of the RTI Act, has provided the right to information to all the citizens, subject to the provisions contained therein. Full stop. Section 2J has prescribed, provided a definition, has defined, as per Section 2J, quote unquote, a right to information means so and so. Public authority, as per Section 2H, means so and so. Obligation to provide information is cast under Section 4, obligation is cast on every public authority to provide information. To maintain its records and to facilitate right to information under the RTI Act. Full stop. It has been made mandatory by the provisions of Section 5 to appoint Central Public Information Officer or State Public Information Officer, as the case may be, in all administrative units or offices. Full stop. A person as per Section 6, a person who desires to obtain any information under the RTI Act, can make a request in writing or through electronic means. Accompanying such fee as may be prescribed. Specifying the particulars of the information sought by him or her before the concerned public information officer. Full stop. Subsection 3 of Section 6 has provided that where an application is made to a public authority requesting for an information, Roman 1, small, which is held by another public authority, semicolon, or Roman 2, the subject matter of which is more closely connected with the public authority, to which such application is made, shall transfer the application or such part of it as may be appropriate to that other authority and inform the applicant immediately about such transfer. Full stop. Section 7.
Yes, secret lord. Yes, secret lord.
After a request for information is made, the primary obligation of consideration of the request is of the public information officer as provided in section 7. Post of such request has to be disposed of as expeditiously as possible. Post of. In any case, within 30 days from the date of receipt of the request. Also, full stop. In any case, either the information shall be provided or the same may be rejected for any of the reasons provided under section 8 or section 9. Post of the proviso to section 7 has made it incumbent that when it concerns the life or liberty of a person, subsection 2 of section 7 has prescribed that if the concerned public information officer fails to give the information specified within a period of 30 days, it shall be deemed that such request has been rejected. Full stop. Subsection 3. Subsection 8 of section 7 has mentioned that whereas so and so, Look at you. Section 8 and section 9 have enumerated the grounds of exemption from disclosure of information and also grounds for rejection of request in respect of some items of information respectively. Section 11 deals with third-party information. First stop. Section 12 has provided for constitution of Central Information Commission and section 15 has provided for constitution of the State Information Commission. Full stop. The powers, chapter 5, the statutory provisions contained in sector 5 of the RTI Act has provided about the powers and functions of the Information Commission, appeal and penalties. Full stop. As the provisions of section 18, section 19 and section 20 have been referred to and are involved in the case in hand, the said provisions are quoted herein below, in its entirety. And come back. Section 18 of the Act, subject to the provisions of the Act, has provided that it shall be the duty of the Central Information Commission or State Information Commission, as the case may be, to receive and inquire into complaints from any person. It appears that the powers under Section 18 of the Act have been categorized under Clause A to Clause F of Section 18(1). First of under Clause A to F of Section 18(1) of the Act, the Central Information Commission or the State Information Commission, as the case may be, may receive an inquiry into complaints of any person who has been refused access to any information requested under the Act, section within bracket section 18(1)(b), or has not been given, has been given incomplete, misleading or false information under the Act within bracket section 18(1)(e), or has not been given a response to a request for information or access to information within the time limit specified under the Act section 18(1)(c). Full stop. In the case in hand, the petitioner as the applicant stroke first appellant stroke second appellant in his complaint dated 21/5/2024 has made a contention that the information supplied to him pursuant to the order dated 6/3/2024 of the Commission, were misleading and not related, misleading and wrong, and were not related to his RTI application. Full stop. Under section 18(3), of the Act, the Central Information Commission or the State Information Commission as the case may be, while inquiring into any matter under section 18(1), have been vested, has been vested with a power, with the same powers as are vested in a civil court while trying a suit under the Code of Civil Procedure, in respect of the following matters, namely A, B, C, D, E, F. CPC Gonçalves. Das The summoning and attendance of the witnesses is dealt with in section 30, section 31, and section 32 of the CPC, which reads as under. The detailed procedure for summoning and attendance of witnesses is dealt in order Roman 16 of the CPC, rules 1, 5, 1, 5, 6, 7, 10, 14, 15, 18, and 20 deal with summoning of witnesses to produce documents. For the sake of brevity, the said provisions are not quoted herein. Full stop. Subsection 4 of section 18. এই ভারত ফোর্স টু লক্ষণ ভারত ফোর্স বলে এটা আছে ইউনিয়ন অফ ইন্ডিয়া জিএসটি কেস of the act is with a non-obstante clause, and it has given overriding power. It has provided overriding powers to the state Central Information Commission or the State Information Commission, as the case may be, to examine any record by laying down by examining any record during the inquiry of any complaint under the act, examine any record to which the act applies, which is under the control of the public authority, and no such record may be withheld from it on any ground. Full stop. Para. If the in the judgment it is true that in Kishan Jain Supra, it has been held that it has been observed that which paragraph, Mr. Deka?
Lordship, 30
Supervisory.
supervisory will be lordship. 20. Okay, that would be 34.
34.
Goes on to the next page.
34.
which is upheld by the
Starts with
section 19(4) deals with the procedure relating.
19.
Section 19(4) deals with procedure relating to information of a third party. 19(5).
No, where it is supervisory some,
That is in the next page, the procedure for hearing.
huh?
No, see, that will be paragraph 35.
30,
Step 35.
35.
Procedure for hearing the appeals have been framed in exercise of power under clause.
35 in Kishan Chand
Yes, Lord.
or in the
In
CIC
the CIC versus
Manipur,
Manipur. And Kishan is 10 paragraph.
paragraph 10.
That is upholding paragraph
Okay,
35.
in the Central Information Commission, Supra. In cell and it is true, like it has been observed in Central Information Commission, Supra, that section 19 and section 18 and section 19 serve two different purposes and lay down two different procedures, and they provide two different remedies, and one cannot be a substitute for the other. Full stop. Where is the supervisory one?
35, Lordship. Line
35.
the procedure for hearing the appeals have been framed in exercise of power under clause E and F of subsection 2 of section 27.
It has been observed that the procedure contemplated under section 19 and section 18 and section 19 is substantially different. Full stop. The nature of power under section 18 is supervisory in character, whereas the procedure under section 19 is an appellate procedure, and the person who is aggrieved by refusal in receiving the information which he has sought for can only seek redress in a manner provided in the statute, namely, by following the procedure under section 19. First. Para. In CIC, Central Information Commission, Manipur, the facts, the backdrop of events can be noticed as follows. The applicant therein filed an application on 9/2/2007 under section 6 for obtaining information from the State Information Commission relating to magisterial inquiries initiated by the government of Manipur from 1980-2006. Full stop. As the application under section 6 received no response, the applicant filed a complaint under section 18 before the State Chief Information Commissioner, who by an order dated 30/05/2007 directed the public authority to furnish information within 15 days. Full stop. The same applicant filed another application on 19/5/2007 for obtaining similar information for the period between 1980-March 2007. Full stop. As no response was received that time also, the applicant filed a complaint again under section 18, and the same was disposed of by an order dated 14/8/2007. directing disclosure of the information sought for within 15 days. Post of the state chief information commissioner were challenged by two writ petitions. Full stop. Both the writ petitions were heard together and were dismissed by a common order dated 16/11/2007. Entirely upholding the order of the commissioner, state chief information commissioner, full stop. A writ appeal came to be filed against both the judgments and the division bench disposed of the writ appeal by the impugn order dated 29/7/2010. Full stop. By the impugn order, the Honorable High Court held that under Section 18 of the Act, the State Chief Information Commissioner had no power to direct the respondent to furnish the information, and further held that such a power had already been conferred under Section 19(8) of the Act on the basis of an exercise under Section 19 only. Full stop. The division bench further came to hold that the direction to furnish information was without jurisdiction and directed the commissioner to dispose of the complaints in accordance with law. Full stop. When the matter reached the Supreme Court, the Honorable Supreme Court, it was contended, when the matter reached, when the matter, when an appeal was preferred against the judgment of the division bench of the Honorable High Court, it was contended before the Honorable Supreme Court that under Section 18 of the Act, the Central Information Commission or the State Information Commission has no power to provide access to information which has been requested for by any person, but which has been denied to him. Full stop. The only order which can be passed by the Central Information Commission or the State Information Commission, as the case may be, under Section 18 is an order of penalty provided under Section 20. Full stop. It has, however, been held that before such order is passed, the commissioner must be satisfied that the conduct of the information officer was not bona fide. Full stop. The said contention was upheld by the Honorable Supreme Court, finding no error in the impugned judgment of the High Court, whereby it was held that the commissioner, while entertaining a complaint under Section 18, had no jurisdiction to pass an order for providing for access to the information. Full stop. For the purpose of dealing with the issue, the Honorable Supreme Court had taken note of the facts of the case and after considering the provisions of Section 18 and 19, including Section 19(8), has gone on to observe, as mentioned above, that the procedure contemplated under Section 18 and Section 19 is substantially different. Full stop. In order to also, comma, it has relied, it has referred to the settled proposition that when a procedure is laid down statutorily and there is, when a procedure is laid down, where a statute provides for something to be done in a particular manner, it can be done in that manner alone, and all other modes of performance are necessarily forbidden. Full stop. If it transfers, it appears that such an observation regarding such an observation not to end sorry, it is necessary to mention that the applicant therein, after not receiving any response in his application, in his application under section 6, the applicant had directly approached the chief state chief information commissioner directly under section 18 without pursuing his remedy of first appeal and second appeal under first appeal under
Section 19(1).
18(1),
19(1).
19(1) and 19(3)
3 is the second.
of the Act. Full stop. And it has, it is in the light of such facts, comma, it has been held that if the contention regarding such procedure is to be accepted, then section 19 would become unworkable, and specially, comma, section 19(8) will be rendered as surpluses. Full stop. It has been held that such an interpretation would be totally opposed to the fundamental canons of construction. The Honorable Supreme Court has gone on to observe as under section para 42 CC2 devotion SCC 2011-15 SSC 1. (42) लिखिए and 43 लिखिए. The Honorable Supreme Court has further taken note of the direction given by the division bench in the penultimate paragraph of the impugned judgment and order, whereby the division bench had directed the Information Commissioner, Chief Ritwasa, to dispose of the complaints of the applicant in accordance with law. Full stop. Taking note of the said direction, comma, the Honorable Supreme Court had directed the appellants to file appeal under Section 19 of the RTI Act in respect of the two requests made by them for obtaining information by the applications dated 9/2/2007 and 19/5/2007 within a period of 4 weeks. With the observation that if such an appeal is preferred following the statutory procedure by the applicants, comma, the same should be considered on merits by the appellate authority without insisting on the period of limitation. Full stop. Insofar as regards the direction made the last concluding direction was set aside from the silo matter. বিষয় বানাই Last part of the direction was set aside.
Okay.
That division bench directed the commissioner to dispose of. After setting aside, it made a contradictory direction. That was set aside.
However, the observation which says is the distinctive nature of that is the.
We'll do that.
Okay.
We'll do that. I am conscious of the fact. The petitioner in Kishan Chand Jain approached the Honorable Supreme Court under Article 32 of the Constitution, seeking direction for the better functioning of the State Information Commissions under the Right to Information Act 2005. Post stop. The Honorable Supreme Court after taking note of the provisions, powers and functions of the Information Commission, under Section 18 and the appellate powers under Section 19, which allows any person aggrieved by refusal of information to seek an effective redress and remedy. Has gone on to observe that the State Information Commissions exercise broad powers, including among them the powers to conduct inquiries into complaints from any person, hear appeals and impose penalties. Full stop. It has been observed that the state information commissions decide on matters and issues pertaining to the right to information, and the information commissions are required to act in a fair and just manner while following the procedure laid down in Section 18, Section 19, and Section 20 of the Act. Full stop. Para. It is settled. It is too settled that it is too settled, as also held in CIC, Supra, and Kisan Chan Jain Supra, that the right to information is not merely a statutory right for. Please take your seat.
My lord,
Why you are standing?
may I come in, my lord, one point? My lord, what my learned friend has, my lord, relied upon the judgment, my lord, your lordship has indicated. My lord, in that case, my lord, directly in application.
I have already recorded. Why you are repeating?
My lord, it was.
Are you not hearing my dictation? Huh? Then why you are repeating then?
They directly.
Have I not dictated about that?
We have
Under 6, then direct 18. That is what I had not dictated. Then why you are interfering?
We have exhausted.
Please don't disturb the thought process. I have already recorded without any kind of submission from your side.
All right.
Right to information is not merely a statutory right, and it has and it is a constitutional right. Full stop. The RTI Act is based on the principle that citizens have a right to know about the functioning of every public authority, and it places a duty on the public authorities to act in a responsible and transparent manner by providing information about their functioning to the citizens. Full stop. It has been held that the freedom of speech and expression under Article 19(1)(a) includes the right to acquire and disseminate information. Full stop. The right to information has also been recognized as a facet under Article 21. Full stop. In Kishan San Jain Supra, it has been held that such a right to information entails a heightened burden and responsibility on the state Central Information Commission and the state information commissions to ensure that the individuals get access to information on matters of public concern under the provisions of the RTI Act. Full stop. The Constitution bans in Onita Kushwara versus Pusap Sadan, 2016, 8 SSC 509 has held that access to justice is a right of Constitution. Access to justice is a facet of Article 21 of the Constitution of India. Full stop. Para. If the submission of the Learned Council, Standing Council, State Information Commission is to be accepted, that the jurisdiction of the State Information Commission under Section 18 being only supervisory in nature, comma, has not vested the State Information Commission to inquire into a complaint of an applicant falling within the purview of any of the clauses from A to F, A to F,
Lordships,
A to F,
the complaint which is filed after the non-compliance.
after A to F of subsection 18, or subsection 8 of section 18 is to be accepted, then with no power on the with no power vesting in the State Information Commission under section 19 of the Act to enforce compliance of its order, comma, the provisions under section 18 of the Act providing the powers to the State Commission to inquire into a complaint of any person, bold, falling within the purview of subsection 1 of section 18 would be rendered odious and superfluous and unworkable. Full stop. The Honorable Supreme Court in CIC's Manipur has already held that an applicant, after submission of an application under section 6, could not have approached the State Information Commission under section 18 directly, alleging refusal of information to him by the public authority. So directly, and what kind of complaint will be entered in then?
Lordship,
What kind of? Supreme Court has CIC held that after section 6, you cannot come directly 18.
only trigger to getting a direction to access the information.
Hmm.
Only under section 18, if.
Now,
under-
why then A to F, Mr. Counsel?
Lordship, can
Anyway,
you take up?
okay,
section
I
18?
have.
And
Okay. Supervision. If after an applicant if an applicant after preferring an application section 6 and thereafter preferring a first appeal under section 19(1) and a second appeal under section 19(3) of the Act, still does not receive the information he has sought for, and in such situation, he is to be prevented to file an application under any of the sub-clauses from A to F for under section 18, then such an application would be left remediless to receive remediless to receive the information he has sought for, and the same will be, and same cannot be, and same does not go together with the his fundamental right of access to information under Article 19(1)(a) of the Constitution of India. Full stop. Para. The State Central Information Commission or the State Information Commissions by holding that the power of the Central Information Commission or the State Information Commissions under Section 18 are supervisory in character, this court is of the considered view. Sorry. It has been settled that so and so have supervisory jurisdiction under Article 18, Section 18. And the same goes to mean that the Central Information Commission or the State Information Commissions have the power, authority, and jurisdiction to pass necessary orders to keep the public authorities over whom it exercises jurisdiction within its bounds and can enforce compliance of the provisions of the right to information to the applicants. Full stop. Para. The State Central Information Commission and the State Information Commissions are statutory authorities established under Section 12 and Section 15 of the RTI Act. Full stop. The powers and functions of these information commissions are well delineated in Section 18, already quoted here in above. Full stop. In Section 18, it has been, the legislature has incorporated that it shall be the duty of these commissions to receive and inquire into a complaint from any person on any of the issues covered by A to F of subsection Section 18 to full stop. Para. Add this, add this, comma, it would be appropriate to refer to the scope of a writ in the nature of mandamus. Full stop. It is settled that a writ in the nature of mandamus would lie when a statute imposes a duty and there is failure in discharge of duty. Full stop. It is also well settled that the High Court, the High Courts, it has been well settled that the jurisdiction under the jurisdiction, sorry, Article 226 of the Constitution of India. So, sorry, this court's jurisdiction. Now, while exercising jurisdiction under Article 226 of the Constitution of India, this court has the power to issue a writ of mandamus or a writ in the nature of mandamus, or to pass orders and give necessary directions where the government or a public authority or a statutory authority has failed to exercise or has wrongly exercised a discretion conferred upon it by a statute or a rule or a policy decision of the government, or has exercised such discretion mala fide or on irrelevant considerations, or by ignoring the relevant considerations and materials, or in such manner as to frustrate the object of conferring such discretion or the policy for implementing which such discretion has been conferred. So in all such cases, and in all other fit and proper case, a High Court can, in the exercise of its jurisdiction under Article 226, issue a writ of mandamus or a writ in the nature of mandamus, or pass orders and give directions to compel the performance in a proper and lawful manner of the discretion conferred upon the statutory authority or the public authority, and in a proper case, in order to prevent injustice resulting to the concerned parties, the court may itself pass an order or give directions which the public authority or the statutory authority should have passed or given had it properly and lawfully exercised its discretion. 1986 2 SCC 679. In Andi Mukta Sadguru Sri Muktaji Banda Swami Subarno Jayanti so 1989 2 SCC 691. The Honorable Supreme Court has held that the para 20 while dealing with the word authority used in Article 226 of the Constitution of India, and also dealing with the issue as to whether a writ of mandamus or a writ in the nature of mandamus will lie even if the duty is not imposed under a statute, has held as follows: para 20. Full stop. In when it is also settled in so and so asset reconstruction. Oh no, sorry. After considering a number of precedents, comma, the Honorable Supreme Court on the scope of mandamus or scope of a writ of mandamus, the Honorable Supreme Court in Union of India and others versus Bharat Forge and another 2022-17 SSC 188 has held that a writ of mandamus or a direction, comma, in the nature of a writ of mandamus is not to be withheld, comma, in the exercise of powers of Article 226 on any technicalities. Full stop. This is subject only to the indispensable requirements being fulfilled. Full stop. There must be a public duty. Full stop. While the duty may arise from a statute ordinarily, the duty can be imposed by common charter, common law, custom, or even contract. So the fact that a duty may have to be unraveled and the mist around it cleared before its shape is unfolded may not relieve the court of its duty to call out a public duty in a statute or otherwise, if in substance it exists. Equally, a mandamus will lie if the authority, which had a discretion, fails to exercise it and prefers to exercise it. Full stop. A writ of mandamus or a direction in the nature thereof has been given a very wide scope in the conditions prevailing. Has given a wide scope, and it is to be issued wherever there is a public duty or a statutory duty and there is a failure to perform, and the courts will not be bound by technicalities, and its chief concern should be to reach justice to be wrong. Full stop. Para. The phrase, quote unquote, any person, appearing in section 18 is not defined anywhere in the Act. Full stop. As the phrase any person appearing in section 18 is without any restriction, comma, the same would include an applicant also who approaches the commission after being with a contention that after exhausting the procedure outlined in section 6, section 19(1) and section 19(3) of the Act, that with the approaches that so and so, with a complaint that the information supplied to him were either misleading or not related to, or misleading or wrong. And there was willful disobedience and deliberate non-compliance of the direction given by the commission under section 19(3) in a second appeal under section 9, preferred under section 19(3) of the Act. We'll deal with, come back.
Yes, Lordship.
Yes, anything?
Lordship, only one point, under section 18, if we deal with a complaint after of non-compliance, we still clutch not to pass an order to access the information as per the order of the Supreme Court. We can only penalize. So if the fundamental rights of the petitioner.
I'm trying to distinguish. That is not
Lordship, but-
the appropriate. I'm holding you have a right to appeal.
No, I'm just.
You have a
saying,
right to.
We cannot
I'm
even
saying
give
that-
access to the information. We'll only can penalize.
You can, I have, that is why I have quoted section 30, 31, 32, and order 16 of the CPC. Knowing that this would come from your side.
Like,
Hmm? Sujordev Rai. 2003 6 SSC. 2003 6 SSC. 675. Last time কোনটো আছিল? Applicant. Huh? Applicant. When a statutory authority is vested with a jurisdiction which is supervisory in character. Supervisory in character. Comma is exercisable. Such supervisory jurisdiction is exercisable when any of the authority over whom it exercises jurisdiction, comma, or it exercises such supervisory jurisdiction, comma, is is
Let's.
নহয় comma exact word তোমাৰ চাই দিছো is when such a authority has assumed a jurisdiction which it does not have or has failed to exercise a jurisdiction it does have or the jurisdiction, though available, is being exercised in a manner not permitted by law. Full stop. In the case, reverting to the facts of the case in hand, the petitioner in his complaint has alleged that the information supplied to him were misleading and wrong. Full stop. When a party questions a failure on the part of a statutory authority to perform its statutory duties, it cannot be said that jurisdiction of the High Court under Article 226 is ousted. And the High Court, in exercise of its jurisdiction under Article 226, finds that there is failure on the part of the statutory authority to stick to adhere to the mandate of law. Comma. The jurisdiction is can be invoked to ensure that the statutory authorities perform their duties within the bounds of law. Full stop. The in the light of in view of the above discussion, comma, this court finds that the State Information Commission, on receipt of a complaint of the nature discussed herein above, comma, owes a duty to exercise its jurisdiction under section 18 of the Act. By taking cognizance of a complaint received from any person, including an applicant, who has exhausted the remedy of under section 6, comma, section 19(1) and section 93 of the Act, comma, on its own merits, by initiating an inquiry as contemplated under section 18, if the complaint contains if the contents of the complaint falls within any of the clauses from A to E of subsection 1 of section 18 of the Act. On reaching a satisfaction that there are reasonable grounds to inquire into the matter. Full stop. It is needless to say that in causing such an inquiry, the Commission is vested with the jurisdiction as delineated in subsection 3 of section 18 of the Act. Full stop. Para. Though this court has taken notice of the nature of information sought for by the petitioner as an applicant under the RTI Act and the information supplied to him by the public authority on 16/10/2022 and the information supplied to him by the public authority on 13/3/2024, comma, this court has not made any observation as regards the merits of the complaint made by the petitioner in his complaint dated 21/5/2024. Full stop. It is, but, comma, from the text and tenor of the complaint dated 21/5/2024, From the nature of allegations, sorry, to extent, from the contents of the complaint. Also, though the petitioner in his complaint dated 21/5/2024 has not mentioned under which provision of the RTI Act 2005 the said complaint has been submitted. The complaint has, however, full stop. But the same, but not omission on the part of the petitioner to mention the mention the provision of law shall not preclude the commission to examine as to whether it falls within the ambit and purview of any of the clauses from A to F of subsection 8(1) of section 18 of the Act. In such such view of the matter, the contention of the learned counsel for the learned standing counsel KAAC that the said complaint is not to be entertained because of omission on the part of the petitioner to quote the provision of law after consideration is found unacceptable. Full stop. Para. In view of the above discussion, in view of the above discussion and for the regions assigned here in comma, this court is of the unhesitant view that the commission shall take the complaint dated 21/5/2024 submitted by the petitioner before it on board and after reaching a satisfaction as to whether there are reasonable grounds to inquire into the matter. Shall proceed to decide as to whether an inquiry is necessitated or otherwise on its own merits. It is further clarified that this court has not made any observation as regards the merits of the complaint, meaning thereby, the commission will exercise its discretion vested on it under section 18 of the Act. We'll make some correction.
But some time period may be given.
Huh?
because my lord already is from 2020.
Uh,
Within a period of 3
it
months.
is further observed that the commission shall, any timeline, is there any rules?
For the second appeal, there is no 18, there is no.
Ah.
19/6 is the timeline for first appeal.
Generally,
Shall
it is
proceed with the matter as expeditiously as possible and the petitioner is to provide it an opportunity of being heard. A petitioner, the petitioner and other stakeholders are to be provided with a reasonable opportunity of being heard in the event the commission decides to proceed
Yes.
with an inquiry, Full stop. I'll think about it, about the expeditiousness.
Okay.
Well,
Proceed
it's-
with utmost expedition.
preferably
You'll
within a
be,
period of 9
no,
months.
see, this timeline is, there is no timeline.
It is there, my lord, in case of 30 days. Thereafter.
It is not 6, Mr. Singh. It is 18. It is 18.
18, yes. 18.
There are civil code procedure is
Yes.
incorporated in it. So someone, all these are there. And it says neither the Supreme Court nor the High Court should fix a timeline to complete. Right. So we'll not do that as expeditiously as possible.
As
It
expedient.
will be provided with opportunity of hearing and it will go on its own. If really it is prolonged, then you come, we'll see to it. I'll make some correction, some cosmetic.
Like,
Deeply obliged, my lord.
We'll deal with some section 21 or 2 line,
yes, Lord.
just 1 or 2 line. That complaint is one, appeal is one.
Okay.
Both are separate.
Like, Lord.
Highly obliged.
Motion गिरा था ना? अपनी जाओ. कौन बेरा ऊपर पास? Yes, I mean, Sahali.
Supplementary list, items 22 to 24.
All are similar or different?
Single lordship, I will give the chart lordship.
I'll go into it. Okay. लिखियो. Oh. Where is Mr. Gogoi?
He's on his way, my lord.
হেৰি কৰিব
I've
কোন
prepared.
আহে বা
All are similar lordship. In all the cases, lordship, lordship may kindly see point number 2. So-called notice issued by another authority and the lordship 6, the order is passed by some other authority. And in all the case, freezing of bank account is there. They have freezed all the bank accounts. Connected matter,
basically the concluding direction will be about
pre-deposit.
pre-deposit,
Lordship.
but still we have to note the facts.
Lordship. The court has lordship.
What is the first one? Is petition. Probably we see. First two kuntu. Silly first kuntu. No, 5538 to your court. 5538. We'll deal with it. 5538. Morgina Bibi. আহিব কোনোবা অনন্তই মানে বহুত ভুল কৰে দেই
Lordship, in the
Yeah, I don't know.
5538.
Will not serve any purpose. And there is some, it has to be arranged.
Petitioner Lordship. Just now I have been informed that Mr. B who is on legs in court number 4, my lord. He is occupied in some contempt measures, my lord.
We'll deal with the facts by the time he will come.
My lord.
Otherwise, his submission will be recorded. Yes,
He has already submitted.
advance his submission
My lord.
that the petition is not to be entertained, right?
In view of Godrej Sarali.
And the petitioner should be relegated to the appellate remedy, but only so far as pre-deposit is concerned, bank account amounts are to be taken, and whatever deficit that petitioner will provide.
Yes, your Lordship.
That is a
That is the Lordship. That
sum and substance.
Lordship, the sum and substance is that, Lordship, that since the amount is attached in the bank account, so they need not press for
If
pre-deposit.
it is not sufficient,
But it is not sufficient, I need to take.
that is what I am saying. Okay, তিনটা বেলা বেলা লিখিব। প্ৰত্যেকটোতে তিনটা বেলেগ বেলেগ হ'ব, বেলেগ বেলেগ লাষ্টত কমন এটাই হ'ব, কিন্তু তিনটা বেলেগ বেলেগ ডেটবোৰ বেলেগ বেলেগটো নহ'লে পিছত কনফিউজন হৈ যাবে। Okay. You take 5538, right? The petitioner number 2 carries out her business in coal under the name of and style of petition number 1 or the petition number 1 with a certificate of registration bearing registration number so and so 18 or Parambo Arot says. Full stop. The petitioner has averred that the petitioner is entitled to input tax credit ITC in respect of purchase of coal under the provisions of the Central Goods and Services Tax Act CGST 2017 stroke State Goods and Services Act SGST 2017. So the petitioner has contended that all the refunds were duly sanctioned and disbursed after causing full inquiry. And the respondent number 4 is a jurisdictional officer insofar as causing inquiry in respect of the assessment of the petitioner and its entitlement to get refund of ITC on zero rated supplies. First stop. The petitioner has further stated that a demand cum so cause notice dated 8/4/2024 stood issued to it along with under section 73 of the SGST Act. Correct?
Lordship 74.
74. Suppression. Suppression kind of thing. Okay. SGST Act stood issued on 8/4/2024 under section 74. Sorry. Let me like you. Along with followed by Form GST DRC 01 under Rule 100 within bracket 2 and Rule 142(1)(a) of the corresponding rules on 9/4/2024. Full stop. By the demand cum show cause notice, a huge amount of tax and interest amounting to rupees 1,23,45,517 has been demanded for the period April 2022 to March 2023. With the allegation that the petitioner had claimed erroneous refund. Full stop. In a demand cum show cause notice, it was mentioned that on 2/9/2022, the petitioner claimed a refund of rupees 47, 54,424 for the tax period from March 2022 to August 2022 by stating the region of refund as quote unquote refund of ITC on export of goods and services without payment of tax unquote. Full stop. Consequently, a refund amount was sanctioned on 7/9/2022 for rupees 54,424 packet of return or was page 47. Full stop. In the said so cause notice, the adjudicating officer had further mentioned that upon verification, it was found that the petitioner, SSC, had not received any input ITC during the period from March 2022 to August 2022, against which the refund was claimed. Full stop. On receipt of the said demand cum show cause notice dated 8/4/2022, the petitioner stated to have submitted a reply on 4/5/2024, 14/5 in form GST DRC 06. And in the said reply, the petitioner requested to refix the matter after 4 weeks. To enable the petitioner to go through the notice and to check its own documents and papers, as well as the transactions for the period, and to do the needful thereafter. Full stop. The order in original under Section 74 came to be passed by the adjudicating authority on 11/9/2024. With a demand of rupees
1,27 lakhs
1,27,45,000 as tax, interest, penalty for the period from April 2022 to March 2023. And the petitioner has been directed to make payment by 11/10/2024, failing which proceedings would be initiated against the petitioner to recover the outstanding dues. Full stop. The order in original dated 11/9/2024 is accompanied by Form GST DRC 07 and the Rule 142(5). Sorry, accompanied by a summary of the order dated 11/9/2024 in Form GST DRC 07 and the Rule 142 (5). Full stop. It is the petitioner has mentioned that, has stated that at the time of, prior to or
At the time of issuance of.
at the time of
issuance of-
issuance of the demand cum so cause notice, comma, the bank account of petitioner,
Has been frozen, Lordship, it is mentioned at page 49,
page 49,
paragraph 3.
page 49.
Third paragraph.
Okay.
Third paragraph.
Mm.
After the chart, the third paragraph.
Ah.
Considering the above. The bank account
Mhm.
of taxpayer.
Ah.
Was frozen on 5/4/2020.
By the demand cum so cause notice dated 8/4/2024, comma, the adjudicating officer finding the alleged discrepancies stroke anomalies grave in nature, posing a serious threat to the interest of revenue, comma, has froze the bank account of the petitioner, number so and so, page 49, Gul kore disu. Maintained at maintained at Dhubri branch of Axis Bank on 5/4/2024. Full stop. This is the fact.
Yes.
Contention will be same. Next is 5/539. Meaning thereby adjudicating authority is same. Ah.
All the same, all the cases,
Ah.
all the cases.
No, you are taking a plea. Issued by 3, passed by 4. Where? I don't think it is the case there.
No, no, that is the case, Lordship. Lordship may kindly see the so-called notice is issued by the Deputy Commissioner. Lordship may kindly see
Hmm.
the DRC on page 47.
Okay.
Lordship, the page 50, Lordship will kindly see
Deputy Commissioner.
Deputy Commissioner, and the order has been passed by the Assistant Commissioner.
Okay.
But this issue has been considered in the similar matter, para 2.
Okay,
Roman 2.
okay. Now, has it been a case of personal hearing? It would have been somewhat different.
Okay.
But in the reply itself, no.
One is not
So it is not a case that the authority who hears
Yes,
must decide the matter. Next লিখক 5539. GST registration number লিখিব চাই পেলাই কোল same thing, petition number 2, petition number 1, huh? Okay. Registration number is different. Coal.
Full.
Input tax credit, SC, ST, so and so, so and so. Same. Eta লিখিব demand cum so cause notice dated 18/6/2024. Section 74 same. আৰু GST DRC 012 19/6/2024. Amount is 1,05,29,814. Correct? এতিয়া এই যে এটা আছিল আগত যে ক্লেইম ৰিফাণ্ড সেইটো পেৰাৰ ঠাইত ইয়াতে আছে page 47ত first para or second para. The 12/8 claim refund of so and so, so and so. Reply
In this case, no reply.
page.
Lordship, in this case, they did.
Okay. Reply to বাদ দিব. Reply line to বাদ দিব. Order in original
1/16/8/2024.
page
53.
16/8. 2024. Order 19th, I'm sorry, order in original is 16/8/2024. Amount is 1,06,59,000. Aru to make payment by 31/8/2024. Aru GST DRC 07 also 16/8/2024. Bank account
Page 49, same. You want from same date. Account is
49
different.
49 my paragraph to ভুল করে দিছে sorry Axis Bank Dhubri
Okay.
5/4/2024 account number mention আছে এটা বাকি নাকি grave serious threat to the interest of a revenue. Five, 686. Coal?
Full.
Coal. Input tax credit, so and so, GST registration number to paragraph 3 আছে. Notice page
58.
PS 50 আছে. Demand comes show cause notice under section 74. Date 8/4/2024. Period 2022, 2023 and 2023-2024. Erroneous amount 1,11,23,972. আৰু এই যে কোনদিনাখন কি ক্লেম ৰিফাণ্ড কৰিছে paragraph page 58 paragraph number 1 and 2. Our summary of so-called notice form GST DRC 0194/2024. Any reply?
Yes. Page 71.
Page
71.
70. No, here there are two notice here.
Yes, Your Lordship.
Something different.
What did they issue?
Something different. এনেকে লিখো এইটো কমপ্লিট অলপ বেলেগ মানে হেৰি লৈ
Some amount they have increased, Lordship. Finally, order has been passed, one order only, but they have increased some amount of interest.
Here two notices.
Two notices they have increased.
Two notices by respond number 2 and respond number 3. Is it not? This case is slightly
Not covered. my lord.
Huh?
In that case, Lordship will keep it, my lord, I'll let me have the answer.
Huh?
Lordship, in this
One at
case,
66, one at 58.
Right.
Two suppose.
Two so-called.
two
Yes.
so-called.
Okay, এনেকে লিখো
Finally, order is one.
Final order is one.
1 minute.
But it refers to one focus notice. Lordship may kindly see page 72,
page 72.
12/8/24. That is the.
Single Soko's notice.
Okay, we'll look at that. Demand comes focus notice, by respondent number 84/2024 যে দুবাৰ repeat হ'ব এইটো বস্তু বুজিছে demand comes focus notice under section 74 আৰু date is 8/4/2024.
There are two summary to the.
1 minute, madam. 1 minute, let me concentrate. It is very difficult if you interrupt. By the respondent number 3. Two erroneous demands amounting to rupees 1,11,23,972 during the years 2022-2023 and 2023-2024. Post-up. In the demand comes show cause notice, comma, the respondent number 3 had claimed as under PS 54 or paragraph 1 and 2 code kore dibo. The respondent 3 has further mentioned that upon verification, it was found that the petitioner did not receive any input tax credit during the period from October 2021 to February 2024, against which the refund was claimed. Full stop. The said demand comes show cause notice was followed by a summary of show cause notice dated 9/4/2024. Inform GST DRC 01 under Rule 100 within bracket 1 and Rule 142(1)(a) of the corresponding rules. Full stop. Thereafter, comma, another demand comes show cause notice.
No, it's summary to Soko's notice.
What is 66 then?
Yes.
DRC one, Lordship. It's
Huh?
DRC one. Part of summary to Soko's notice. This is part of summary to DRC one only.
Madam, first come to page 58
Yes, Your Lordship.
and lastly at page 62.
58 is Lordship Soko's notice.
Oh,
And the
please come to page 58.
58, yes, Your Lordship.
Look at the letterhead.
Yes, Your Lordship.
Deputy Commissioner of State Tax,
State tax.
right?
Yes.
And see page 62, who signed it? Deputy Commissioner,
Yes, Your Lordship.
right?
Yes, Your Lordship.
Then come to page 63,
63.
that is DRC.
DRC is 0.
And the end of it is page 65,
Deputy Commissioner.
Deputy Commissioner. Then see, that next is,
66 will be part
Deputy
of 68,
Commissioner.
Lordship.
huh?
66 will be
Is
part
part of
68.
68, okay.
Nowhere mentioned. Madam.
Huh?
Nowhere mentioned because there is different. It is 12/8/2024.
That is why I am,
Yes.
why you are trying to differentiate 66 is part of,
68. Lordship, the
no, it is not, 66 is part of 68,
68.
yes.
66 is part of
And here, see the signature, 67,
Yes, Your Lordship. The
that is your case,
Yes, Your Lordship. The
right? I am trying to do that only. Why you are making
In
confusion?
the impugn order, so many the reference is of 12/8/2024.
Right, then after the first demand, that is what I am trying to
Yes, yes.
reflect.
First, suppose is still there, sub it appears.
Yes.
Without a mention.
After, thereafter, comma, another
summaries. What? Do summaries of them. It is system to the Deputy Commissioner.
the respondent number 4 on 12/8/2024 had issued a summary of so-called notice for the periods 2012-2023 in form GST DRC 01 under Rule 100 within bracket 2 and 142(1)(a) of the corresponding rules, stating that the petitioner claimed to erroneous refund amounting to rupees 34,30,591 for the year 2022-2023 and rupees 76,93,381 during the year 2023-2024 in the following manner, page 66. The respondent number 3 had further mentioned that upon verification, it was found that the petitioner had claimed ITC fraudulently without receiving proportionate ITC in 2A during the period from March 2022 to February 2024, against which refund was claimed. Full stop. But it is in response to the demand cum so-called notice dated 9/4/2024, the petitioner stated to have submitted a reply to the so-called notice in form the GST DRC 06, stating inter alia that the petitioner, the matter be refixed after 4 weeks to enable the petitioner to go through the notice and check its own documents and papers as well as the transactions for the period and to do the needful thereafter. Full stop. তাৰপিছত লিখিব order in original যে আছিল সেইটো 12/8/2024 period April 2022 March 2024 under section 74 by whom?
By the respondent number 4.
Respondent number 4. Aru forms GST DRC under Rule 142(5) dated 6/9/2024, hoisting a liability of rupees 2,41,078,000, 2,41 lakh, page 74. Is it correct?
2,41,78,000.
2,41,78,961 and date by which 6/10/2024, failing which so and so.
Which is the attachment of bank account is at 60.
Where it is
Page 61.
61. Page 61, bank account boxes. Box, দুটা account. Abdul Khalek Sahida Bibi, তিনটা. Bank account of petitioner,
And the relative.
number so and so, maintained at Dhubri branch, Axis Bank, as well as the accounts of 2 other persons, that is of Abdul Razak and Sahida Bibi, number এটা দিয়া আছে, maintained at the Dhubri branch of Axis Bank on 2/4/2024, right? Vera. গোটেইকেইটা লিখিব মিছ হাৱেলিয়া লাৰ্নেড এন হাৱেলিয়া লাৰ্নেড কাউন্সিল ফৰ দ্য পিটিশনাৰ and Mr. B. Gogoi, Learned Standing Counsel, Finance and Taxation Department for all the respondents. Post up. গোটেইকেইটাত কমন এটা common. The MS Hawalia Learned Counsel for the petitioner has submitted that this is common, huh? That in response sufficient though oh boy where you did not submit any reply.
Lordship, in two cases.
Okay, okay. Edu para hori to.
5538 and 5686.
Which one? 5538 you submitted a reply. And 5686, right? 5538 or 5686. So it para common. MS Hawalia Learned Counsel for the petitioner has submitted that in response to the demand cum show cause notice, the petitioner had immediately submitted a reply seeking time to examine the records and documents at its disposal so as to enable it to file an effective reply. And therefore, in the reply so submitted, the petitioner sought refixation of the case, hearing of the case after 4 weeks. Post up. But the adjudicating authority, without giving any heed to the said prayer, had proceeded to pass the order in original under section 74. Post up. Impugned in this writ petition. To Russell 5538. Sorry, 5539. Paragraph 2. The MS Hawalia Learned Counsel for the petitioner has submitted that after receipt of the demand comes show cause notice under section 74 of the SGST GST Act, the petitioner could not submit any reply. Post up. MS Hawalia has also further contended that no opportunity of personal hearing was afforded to the petitioner, nor the adjudicating authority decided to adjourn the hearing for another date with notice to the petitioner. Post up. Without any kind of opportunity of hearing to the petitioner, the adjudicating authority proceeded to pass the order in original on 6/9/2024. Post up. Para. It is further para. That's a common. Oh, sorry. In item 22, MS Hawalia has further contended that initially it was the respondent number 3 who had issued the demand cum show cause notice, and the petitioner, you responded to that. The petitioner submitted its reply seeking refixation of the case. Post up. But subsequently, the respondent number 4 issued the demand notice and the demand notice also under section 74 of the SGST GST Act for the same period. Post up. As the petitioner sought time in respect of the demand cum show cause notice issued by the respondent number 3, the petitioner did not thought it fit not to submit any reply, as the petitioner intended to take part in the hearing of the proceedings initiated by the respondent number 3. Full stop. But the respondent number 4, without affording any kind of opportunity of hearing, proceeded to pass the impugned order in original on 6/9/2024, illegally foisting liability upon the petitioner. Right? Full stop. It is thus the contention of MS Havilia that two authorities, as an adjudicating authority, cannot initiate two parallel proceedings. Full stop. Moreover, initiate proceedings, parallel proceedings, and such action on the part of the respondent authorities are clearly violative of the provisions of the CGST and SGST Act 2017. Full stop. Any other contention?
Actually, one more contention was that they cannot pass two assessment or 2 years together. Worship, in that respect.
Ms. Havilia has further submitted that the impugned order in original, and in fact, both the demand cum show cause notices were issued for 2 assessment years in block, and such block show cause notices are not permissible under the law. And as such, the order passed, or the impugned order in original passed by the respondent number 4 as the adjudicating authority is non-esteemed law. Full stop. Para. In response, Mr. Gogoi and Standing Counsel Finance and Taxation Department has submitted that the petitioner has an alternative, efficacious, adequate, and statutory remedy under Section 107 of the CGST/SGST Act 2017. First off, he has submitted that the law is settled that in case of matters pertaining to revenue, or when an alternative, efficacious, adequate, and statutory remedy is available to the assessee, a writ petition under Article 226 is not to be ordinarily entertained. Ordinarily to be entertained is not to be ordinarily entertained unless the petitioner is able to make out an exceptional case. First off, it is his contention that the petitioner has not been able to make out any exceptional case to entertain this writ petition. First off, ATI has noticed this, reply this. Mr. Gogoi has further submitted that after receipt of the demand cum show cause notice, the petitioner, by submitting a reply, had sought time for 4 weeks to enable it to go through the its documents and records, and thereafter to enable it to submit an effective reply. Post op. But after approaching the adjudicating authority with such reply, the petitioner did not revert back to the adjudicating authority to submit its reply, traversing the contentions raised in the demand cum show cause notice.
As the same is apparent from the reply, as well as, because my lord, I have no instruction.
Full stop. He has further submitted that in the reply so submitted, the petitioner had himself stated that he did not need any personal hearing. Right? Full stop. reply this. Itu reply diya nahi. Mr. Gogoi.
because petitioner submitted 4 weeks time in the reply. And my lord, if we see the my lord, date of the impugn order, there has been passed after more than 4 years or 4 months. So otherwise also my lord.
I'll do that, but in two, she has submitted reply in one note.
note.
So for his
Yes, yes.
for his
financial
benefit,
part.
Mr. Gogoi had submitted that in the case in hand, despite a receipt of the demand cum succo's notice, the petitioner did not even submit any, had neither approached the adjudicating authority to submit a reply, nor forwarded, nor sought for any further time to submit a reply. Full stop. Common. It is his contention that it is not a case of not providing an opportunity of being heard, and as such, the petitioner's case is not a case of violation of the principles of natural justice. Full stop. Mr. Gogoi, common, has further contended that the adjudicating authority, after issuance of the demand cum succo's notice, had waited for sufficient period of time, and the impugn orders were passed after elapse of reasonable period of time. That is your contention?
Yes, yes.
Full stop. Para. Anything, Ms. Hawley? No. So insofar as full stop. Okay, I have really considered submissions of the counsel for the parties and have gone through the materials on record. Full stop. Written notice. It is well settled that ordinarily in revenue matters, the court does not entertain a petition for a writ under Article 226, where the petitioner has an alternative efficacious, adequate, and statutory remedy, which alternative remedy, sorry, which without being unduly onerous, provides an equally efficacious and adequate remedy. Full stop. The High Court, in its jurisdiction, does not generally enter upon a determination of questions which demand an elaborate examination of evidence to establish the right to enforce which the writ is claimed. Full stop. The High Court does not act as a court of appeal against a decision of a court or tribunal or an adjudicating authority to correct errors of fact, and does not, by assuming jurisdiction under Article 226, trans upon an alternative remedy provided by the governing statute for obtaining relief. Full stop. Where it is open to the aggrieved petitioner to move another tribunal or even itself to another jurisdiction for obtaining redress in a manner provided by the governing statute, the High Court normally does not permit. By entertaining a petition under Article 226 of the Constitution of India, by machinery created by the statute to be bypassed, and we leave the party applying to it to seek resort to the machinery so set up. Hansing Natfall, Superintendent so-and-so, 1964, SC 1419. Full stop. In The rejurisdiction the High Court also has the discretion to entertain or not to entertain a writ petition. Full stop. A exception to the rule of alternate remedy arises when A. The writ petition has been filed for the enforcement of a fundamental right protected by Part 3 of the Constitution. B. There has been a violation of the principles of natural justice. C. The order or proceeding are wholly without jurisdiction. Or D. The virus of a legislation is challenged. Full stop. Para, insofar as the case in hand is concerned, comma, it has emerged that there is violation of the principles of natural justice only on the ground that after submission of the reply by the petitioner seeking time, it would be duta. The adjudicating authority did not apprise the petitioner about the next date of hearing in connection with the demand comes show cause notice on the reference. Full stop. The petitioner in its reply submitted after the demand comes show cause notice, comma, had itself mentioned that it do not avail the opportunity of personal hearing. Full stop. Privacy, comma, the case is not one which falls in the category of no opportunity. Full stop. There is a distinction between a case where there is a violation of the rule of odi alteram partem with no opportunity, and a case where there is violation of a facet of the rule of odi alteram partem. In that, the concerned person was the noticee was not afforded adequate and effective opportunity. Full stop. Privacy, comma, the petitioner is not in a position. It does not emerge from the facts of the case that the petitioner was not provided with any kind of prior opportunity of hearing before issuance of the impugn order in original. Full stop. Itutliko. In the case in hand, comma, it is not the case of the petitioner that the petitioner did not receive the demand cum show cause notice. Full stop. On receipt of the demand cum show cause notice, comma, the petitioner ought to have approached, ought to have replied to the said demand cum show cause notice. Full stop. Merely by issuance of a show cause notice, comma, the so and so in a show cause notice, comma, an adjudicating authority records its privacy observation, and with the issuance of a mere show cause notice, comma, it cannot be automatically held that the adjudicating authority would proceed to determine the case only as per the demand comes show cause notice, full stop. A show cause notice is only a stage for the process resulting into culmination of an order. Full stop. If a noticee after issuance of a show cause notice, comma, is able to show that the basis of show cause notice is not available, then the proceeding initiated by the show cause notice may culminate into an order exonerating the noticee from all the liability. Full stop. With the petitioner not availing the remedy of submission, with opportunity of submitting a reply to the show cause notice, comma, the petitioner in this case cannot raise a ground that it is a case of no notice, no opportunity. Full stop. Para. Block was dealt with in the other case. Block notice was dealt with in the other case.
No, my lord, though, my lord, that it was pointed out that has not been mentioned. Lordship has not dealt with in this case. It will be helpful. That option part, my lord, that's open.
ইয়াৰে এইটো ব্ৰহ্মপুত্ৰ পেৰা 17 লিখি দিব, পেৰা 17 লিখি দিব।
ঠিক আছে।
Section 107. Is it same? Same in SGST 107.
Yes, sir, same.
Has provided for appeals to an appeal to the appellate authority, and it reads as under. Subsection 1 of section 107 as provided that. Subsection 1 to লিখে লিখো। যিটো দুখন নোটিছ আছে। The point raised in this writ petition that the respondent number 2, 3 and respondent number 4, both as adjudicating authorities, initiated proceedings under section 74 is concerned, the petitioner can raise the same in an appeal preferred under section 107 before the appellate authority, and the appellate authority is well empowered to deal with such an issue. Full stop. Parallel proceeding the petition, it is also it is also available for the petitioner to raise the contention that the notice, so-called notice, and the section 74, so-called notice and the order in original passed under section 74 are for a block period. It is available to raise the contention so before the appellate authority. Full stop. In view of the fact that a statutory adequate alternative efficacious remedy of appeal has already been provided for to assail an order like the order in original dated so and so before the appellate tribunal having the power to deal with all such issues. This petition preferred under Article 226 of the Constitution of India is not to be entertained at this stage, reserving the liberty to the petitioner to avail the statutory remedy of appeal under Section 107 of the so and so Act. It is accordingly observed. Full stop. Para. The petitioner has further also contended that the bank account of the petitioner এটা তিনটা আছে দেই item 22 তিনটা আছে namely so and so maintained at Axis Bank of the petitioner, Axis Bank Thubri branch has been freezed, and due to such freezing of the account, the petitioner is not in a position to deposit the pre-deposit amount of 10% in preferring the statutory appeal under Section 107 of the Act. So MS Hawlia has submitted that in a writ petition, WBC number so and so, involving similar issue, a coordinate bench of this court. That is 4694. Is it so?
Yes,
9-4.
4-6-9-4.
Has granted, has extended a benefit to the petitioner therein, who is similarly situated like the petitioner herein. By waiving the pre-deposit of 10% of the tax amount. No, by permitting the appellate authority, by directing the appellate authority to permit the petitioner to file an appeal without pre-deposit subject to the accounts which have been frozen, has deposits equivalent to or more than the amount required to be deposited in terms of Section 107 within bracket 6 within bracket B of the CGST as GST Act. MS Hawlia has thus submitted that similar benefit should be extended to the petitioner herein, as its bank account has remained frozen since so and so. Post up. In reply, Mr. Gogoi has submitted that such an observation can be made, such a direction as directed in the judgment and order dated 18/9/2024, passed in WBC 46-94-2024 can be made with similar terms and conditions. Post of para. In the writ petition 4694/2024, the bank account of the petitioner therein stood frozen after issuance of a demand cum show cause notice under Section 74 of the Assam Goods and Services Tax Act 2017. Post of. While not entering the writ petition, it was observed that if the accounts has to be bracket of return frozen by the order of the adjudicating authority, were still operational on account of the unoperational on account of the freeze, the appellate authority observing that the appellate authority has been directed to permit filing of the appeal as well as to entertain the appeal without pre-deposits, subject to the accounts which have been frozen, have deposits within bracket as equivalent or more than the amount required to be deposited in terms with Section 1076B of the 2017 Act. Post of. It was further observed therein and directed that in the eventuality the amount lying in the frozen accounts mentioned in the show cause notice were not equivalent requisite for the pre-deposit in terms of Section 1076B of the 2017 Act, the petitioner therein was permitted to deposit additionally so much of the amount before the appellate authority so as to fulfill the mandate under Section 1076B of the 2007 Act. Post of. Para. As the case of the petitioner herein appears to be similarly situated, this court is of the considered view that while not entering the writ petition, the same can be disposed of with the following observations and directions: balancing the equities and for ends of justice, having regard to the fact that the bank account of the petitioner herein has remained frozen and unoperational since in or about since the issuance of the demand cum show cause notice. If the accounts of the petitioner have remained frozen, the accounts of the petitioner, as mentioned in the show cause notice, dated so and so, have remained frozen and unoperational, the appellate authority is directed shall permit the petitioner to file the statutory appeal, and on filing of the statutory appeal by the petitioner, the appellate authority shall entertain the appeal without insisting for pre-deposit, subject to the condition that the accounts which have been frozen, the details of which is mentioned in the show cause notice dated so and so, have deposits equivalent or more than the amount required to be deposited in terms of Section 16076B of the 2007 Act. Post of. It is further observed that in the event the amount within bracket as lying in the frozen accounts mentioned in the show cause notice dated so and so is stroke are not equivalent requisite for the pre-deposit of 10% in terms of section 1076B of the 2017 Act, the petitioner shall be granted an opportunity to deposit the deficit amount before the appellate authority so as to fulfill the mandate incorporated in section 1076B of the 2007 Act. Full stop. It is further observed that during the appeal proceedings, if the freeze of the accounts mentioned in the show cause notice dated so and so is removed, the petitioner would be required to deposit so much of the amount equivalent to the amount of pre-deposit requisite in terms of section 1076B of the Act for a further continuation and adjudication of the appeal. Full stop. Or else a failure on that count would entail such consequences as the appellate authority decides as per law. Full stop. With the observations made and direction given above, the instant writ petition stands disposed of. Any correction?
No.
A2 last part of it side low. Yes, madam. All three. Open.
Items 25 and 26.
Yes, we'll start, if not possible, Thursday. That opportunity is still available. That shifting.
Stalls have been dismantled, man.
No, that's all. No, I'm not saying that during the interlocutory application that they may be permitted to shift. That is there.
Yes,
that is
opportunity
open.
still available. Even they don't turn up after the judgment, then they may take a decision.
That is their call. It took Kokon. Kokon. Yes, madam. Is there any instruction from Mr. Dubey? Okay, take your seats. I'll be detailing the facts. If anything wrong is dictated, please mention. I'll just come within 2 minutes. Let the PS come. Yes, madam, do you have any item? I don't think these two repetitions are to be disposed of. Yes.
Item number 527.
What are the matters?
This is a allotment is given, they cannot see it by the decision.
Some details, say choose a date. Just it will give MJ Borua S Bora, huh? Item number 527. We'll fix a date. Same. Okay. 3. Okay. Counselor same. 3, 4, 5 to 7. Okay. I'll come back. Just 2. Mr. Sharma, what is the termination notice? Date 28/7/2021.
Connection 96.
20. Yes, Mr. Goel.
Well, I think your lordship may not like other matter. In fact, in item number 13, there is an interim order. That's why that may be confused. In fact, other side also appeared and they are supposed to file, my lord, today affidavit in opposition.
Okay. You want to time to reply?
My lord, they yet to file, my lord. Today they are
Okay.
going to take time for filing.
The council is available.
He was here, my lord.
Mr. Igwell and Counsel for the petitioner is present. The respondents are yet to file their counter affidavits. List the case after 2 weeks.
After 3
3 weeks, full stop. The interim order passed earlier shall continue till
Ma'am.
the next date of listing.
I have a small prayer as well, your lordship. Item number 20, your lordship. It should come up for admission, your lordship. It has been wrongly listed in the hearing column, your lordship.
File over, it was file over. Why?
Lordship, it has not been admitted yet, your lordship. Only notice was issued.
Okay, it is submitted by Ms.
FN Jaman.
F. and Jaman Learned Counsel for the petitioner. The petition is wrongly listed in the hearing column, and it should have been, it ought to have been listed in the admission column. Post of the registry to look into the matter and list the case accordingly after 2 weeks.
Lordship will kindly permit my item number 11 and 12, my lord. These are land acquisition compensation not paid. So may I pray your lordship may fix a date on 28, my lord.
On the prayer of Mr. B. Borwal and Counsel for the petitioners, list the cases on Saidi Wadadi.
On 28.
Check item 20 after 1 week.
2 weeks. Termination notice
Page
dated
96.
28/7/2021 issued by respond number.
Principal Chief Commercial Manager, respond number.
Respond number.
Respondent number 4.
4.
It was withdrawn.
No, that will, I'll record. তাৰপিছত লিখিব ইয়াতে impugned notice inviting tender, a notice inviting tender dated 9/8/2020, same. আৰু vacation notice, same. By the termination notice, it was same. The petitioner's services as commission vendor had been changed and so. Do you have the Padmara's case with you?
I had given a copy.
A copy that reduction.
Paragraph 14 onwards would be relevant.
Okay. এইটো দি দিওঁ, তাতে দি দিওঁ, মোৰ তাত আছে। Okay. Where is that termination notice page, madam?
96.
96 annexure 9.
96. এনেকে লিখিব, এটা লাইন আছে ইয়াতে, by the termination notice dated 28/7/2021, the petitioner's services as commission vendor had been terminated purportedly pursuant to an order of the general manager, NF Railway and AGM means
Assistant General Manager.
Assistant General Manager,
Additional General Manager.
Additional General Manager, NF Railway, allegedly on the ground of unsatisfactory performance. Full stop. Where is the NIT?
Page 98.
98. Okay. By NIT number C-LMG-39-2021, dated 9/8/2021, the respondent NF Railway invited e-tenders from bidders for provision of catering services Page 96. At special minor unit so and so between pillar number so and so, earmark for war, widow, etc. so and so. Huh? Page 96 of us.
98.
98. A বলে লিখেছিস রে, A to A. ঠিক আছে? For a period of 5 years, এগুলো লিখা আছে। By the vacation notice dated, where is that?
Page
2/9/2021. The petition had been asked to vacate the stall at platform number 6/7 of Guwahati railway station within a period of 10 days from the date of receipt of the vacation notice. Departmental stall, right? That's a para 2 change curriculum. The basis of assailment is a letter dated 15/12/2006, page 21, issued by the Assistant Commercial Manager stroke catering for the Chief Commercial Manager. Full stop. It to semi how it is the case of the petitioner that the family of the petitioner was running the business as commission vendor from the same stall located at platform number 6/7 of the Guwahati railway station since about the year 1961. After entering into arrangement with the respondent NF railway authorities, full stop. It is stated that the father of the petitioner was appointed as a commission vendor in the year 1961. And after being so appointed, the petitioner's father was running the said stall as a commission vendor on his term being extended from time to time, till his death in the year 1977. So after death of his father, the petitioner's mother was appointed as a commission vendor in the year 1977. And at that time, the petitioner used to assist his mother in running the departmental store as a commission vendor. When the petitioner's mother expired in the year 2005, the petitioner was allowed to work as a commission vendor, and by the later dated 8/12/2016, the petitioner status as a commission vendor was accorded approval, and the vending license standing in the name of the petitioner's mother, stood transferred in favor of the petitioner.
That is a different order. That is 15/12 and
Okay. Oh, I'm sorry. 8/12/2006 বুলি কৈছো ন?
By that.
কি ক'লো? Okay, 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 okay. After expiry of the demise of his matter, huh? The petitioner was informed by a letter dated 8/12/2006 in response to his application dated 6/4/2006 that on deposit of an amount of rupees 250 as security money along with a surety bond, comma, the vending license standing in the name of his mother would be transferred in the event the petitioner would execute an agreement for commission vendor on a non-judicial stamp paper. Full stop. Subsequently, comma, by letter dated 15/12/2006, comma, the petitioner has been informed to the effect that the competent authority had accorded his approval to transfer the vending license of the petitioner's mother, comma, late Sefali Day, as a commission vendor for the tea stall at the Guwahati railway station under the departmental catering unit in favor of his name with immediate effect, subject to the terms and conditions mentioned therein. Full stop. Subpara. The petitioner's case is that the petitioner had put his best efforts to generate substantial amount of revenue for the respondent NF Railways, and he had made all sincere efforts to run the business as commission vendor effectively and efficiently. Full stop. It is a contention of the petitioner that the petitioner had been running profitably full stop. The petitioner has also referred to the catering policy 2005, catering policy 2010, and the catering policy 2017, formulated by the Railway Board, as well as a decision of the Honorable Supreme Court of India in Senior Divisional Commercial Manager, South Central Railway and others versus SCR Caterers, Dry Fruits, Fruit Juice Stalls, Welfare Association and another, reported in 2016, 3 SSC 582, to support his contention that the respondent NF Railway authorities could not have taken an action like termination by termination notice dated 28/7/2021 and semicolon NIT dated 9/8/2021 and the vacation notice dated 2/9/2021, impugned herein. First of Mr. Dubey, learned counsel for the petitioner. Oh, sorry. First of I have heard Mr. R. Dubey, learned counsel for the petitioner, and Mr. B. Sharma, learned standing counsel NF Railway for all the respondents, Full stop. Para. यहाँ पर साइल हो रही. Mr. Dubey, learned counsel for the petitioner, has contended that the petitioner has been running the business of commission vendor from the location at platform number 6/7 of the Guwahati railway station on the strength of the letters, dated 8/12/2006
15th.
and 15/12/2006, both. And earlier, the business of commission vendor was run by the petitioner's family since last about 5 decades. Full stop. Prior to 2006, the petitioner was assisting his family in running the departmental stall from the same location. Full stop. Mr. Dubey has thus contended that the petitioner, since 2006, has been running the departmental store as a commission vendor on his own. Full stop. As such, and there is no complaint whatsoever as regards deposit of the as regards the business generated by the petitioner from the departmental store as a commission vendor. Full stop. As such, the actions on the part of the respondent railway authorities in deciding to terminate, first by the termination notice dated 28/7/2021, and thereafter, directing the petitioner to vacate himself from the departmental store at platform number 6/7 by the vacation notice dated 2/9/2021 are expressly arbitrary and unjust. Full stop. It is further submitted that it is not open for the respondent NF railway authorities to float a tender for the said departmental store, and as such, the NIT dated 9/8/2021 is liable to be set aside. Full stop. Mr. Dubey has further referred to the terms and conditions incorporated in the letter dated 15/12/2006 to submit that the impugned termination notice dated 28/7/2021 had, however, withdrawn by the respondent railway authorities, and as on date, there is no as on date, the services of the petitioner as a commission vendor is subsisting, and full stop. He has further submitted that by the vacation notice dated 2/9/2021, the petitioner has been was asked to vacate the departmental store. Full stop. Subsequently, during the pendency of the writ petition, the petitioner has been removed from the departmental store with a provision made available to him to relocate himself to another place at the Guwahati railway station. Full stop. It is further submitted by Mr. Dubey that as the location of the stall where he has been asked to shift is not conveniently located so as to generate same kind of business and commission for the petitioner, and the same would create a dent in the earnings of the petitioner as a commission vendor. Full stop. It is his contention that the respondent railway authorities ought to have provided him with a location with a s- with a with a with a with a with a with the same with a similar kind of with a possibility of generating
Similar business prospects.
similar business and to earn commission, proportionate commission. Which would not be to the detriment of the petitioner. Full stop. Mr. Dubey has further referred to a decision of the Honorable Supreme Court of India in Union of India versus Munsiram, 2022, 8 SSC 392, to contend that it is incumbent on the part of the respondent railway authorities to extend the benefit of absorption full stop. He has submitted that in the said case, the case of commission vendors was considered working in different divisions stroke zones in railways were considered for absorption. Full stop. Para. Mr. Sharma Lanet, Standing Counsel, NF Railway, has submitted that there used to be 3 commission vendors at Guwahati Railway Station. Petitioner was the predecessors of the petitioner, and the petitioner were one of such commission vendors. Full stop. The other 2 commission vendors were one, Sri Padmaraj RJ and
Sanju Dutt.
Sri Sanju Datta. Full stop. The case of the petitioner herein is similarly situated with Sri Padmaraj RJ and the matter, the issues relating to and rights of a commission vendor like the petitioner has already been adjudicated in a writ petition WBC number 4430/2021 within brackets C Padmaraj RJ versus the Union of India and others, decided on 12/12/2023. Correct?
Right.
Full stop. It is his contention that out of the 3 commission vendors, only Padmaraj RJ had entered into an agreement with the respondent railway authorities, NF railway authorities. Full stop. So far as the other 2 commission vendors are concerned, he has contended that none of them had entered into any contractual arrangement with the NF railway authorities, and they were running the business on the strength of a letter issued by the respondent authorities permitting transfer of, Sanju is same also?
Same.
Transfer of,
That case, the license is limited by tenure. It is only for 6 months.
okay. Full stop. Insofar as the petitioner is concerned, the petitioner had been running the business as commission vendor from the departmental store at platform number 6/7 on the strength of the letter dated 15/12/2006, which provided for termination on any date without any assigning any region and without any prior notice. Full stop. The case of the petitioner is no different. So far as the status of the petitioner as commission agent is not different to Messrs. Padmaraj RJ, which has been decided by the judgment and order dated 12/12/2023, rendered in WBC number 4430/2021. Full stop. He has further submitted that the relationship between the principal and agent are guided by the provisions of the Indian Contract Act. And an agent, including a commission agent, has to act as per the direction of the principal, which in the instant case is the respondent NF railway. So it is his further contention that even after running the business as a commission agent in departmental store, no right has accrued to the petitioner to claim that he should be granted. No right is vested or accrued to the petitioner to claim that he should be allowed to run his business as a commission vendor from the departmental store located at platform number 6/7 of the Guwahati railway station. First stop. It is the prerogative of the respondent railway authorities to relocate him to another location, if such a location is available, and in other and it is also permissible for the respondent authorities to terminate the commission vendorship of the petitioner without any assigning any region. Insofar as the contention, Mr. Sharma has further contended that the NIT dated
98 page.
NIT number so and so dated 9/8/2021. By the NIT dated so and so. The respondent NF railway authorities had taken a decision to invite e-tenders from eligible bidders for provision of catering services from special minor unit number so and so at platform number so and so between pillar 3-4, earlier used to run as a departmental store, right? Stall.
Yes.
Stall, full stop. He has further submitted that as per the policy of the respondent railway authorities, the said special minor unit has been earmarked for war widow stroke freedom fighter stroke widows of railway employees, who have been dislocated stroke displaced due to their land having been taken over by railway for its own use. First off, he has further submitted that one of the region behind publication of the NIT is to generate more revenue for the respondent railways. Full stop. He has canvassed that the stall located at platform number 6/7 between pillar 3-4 wherefrom the petitioner was running the business belongs entirely to the respondent NF railway authorities, and the petitioner has no right in connection with the said stall. Full stop. When the case of the petitioner is limited to commission only, the decision to award the contract of catering services at the newly named special minor unit number so and so cannot be questioned by the petitioner. As such, the challenge to the NIT dated 9/8/2021 is not maintainable. Full stop. Mr. Sharma has further. ইটো কেছত ন এই ৱাৰ উইডো চুইডো নাই হা সেইখিনি কাটি দিম During the pendency of this writ petition, an issue had arisen as to whether the petitioner commission vendor, whether it is possible to relocate the petitioner commission vendor to an alternate location in other platforms, in the same platform or in other platforms of the Guwahati railway station. Full stop. On the said issue, he had earlier taken instruction in the year 2022 from the respondent railway authorities to stop in a form of written instructions. Full stop. By a letter dated 18/8/2022, instructions were submitted that two number of alternative locations had been identified by the respondent railway authorities in platform number 2/3, right?
Yes, yes.
Of the Guwahati railway station respectively. But at that time, repairing works were carried out. Repairing or constructions were carried out in those two locations.
To construct their stalls only, madam, because the earlier stalls were
Ah.
dismantled.
Construction works. Construction works for stalls were being carried out. Mr. Sharma has submitted that at present, those stalls at the alternate locations are made ready, and the petitioner was offered one of the locations. But it is the petitioner who has declined, who appears to have declined to relocate himself in one of the said two alternative stalls on the pretext that the possibility of generating similar kind of revenue and commission would not be possible therefrom. Full stop. Para. I have given, huh? Para 8 আছে Para 8. The Mr. Sharma has further submitted that the realizing that the termination letter dated 29/7/2021 was inadvertently issued, the same was recalled immediately by another letter number, page 108 also, dated 29/7/2021. Full stop. It is further submitted by him, as adverted to in the affidavit in opposition, that the departmental tea stall was running at a loss. And it was one of the main reasons for the railway administration to decide that the said stall would be converted to
A special minority.
a special minor unit,
SMU.
huh?
SMU in short.
SMU, and would be earmarked as per the policy of the railway, to generate more revenue therefrom on the basis of a competitive bidding process. And it was in that context, NIT dated 9/8/2021 was published to award the SMU to the successful bidder. Post. I have also gone through the judgment and order dated 12/12/2023, passed by this court in the writ petition WBC number 4430/2021. Post of para. In the Writ petition WBC number 4430, 2021, comma, there existed an agreement which remained valid for a period of 5 years from the date of execution, with a provision for extension for further period on mutual consent, comma, subject to satisfactory performance based on the rules, provisions, comma, guidelines, comma, instructions and directives of the railway prevailing at that point of time. Full stop. In clause 5 of the said agreement, in case of Padmaras RJ, comma, the administration reserved the right to introduce the rotational system of vending, and the commission vendor shall raise no objection and was refrained from raising any objection if their duties, comma, place of work was changed by the administration, and the commission vendor was required to perform his duties in a manner stipulated by the administration. Full stop. The said clause further provided that the administration shall have absolute right to assign any other additional duty stroke assignment as the administration would consider necessary in the event of any emergency. Full stop. The court found that the inter se arrangement between the parties as per the agreement was that of the principal, was that of the railway administration as the principal and the petitioner therein as a commission vendor. Full stop. But it is not in dispute that the inter se arrangement of the railway administration on one hand and the petitioner as a commission vendor as on the other hand, comma, is similar, is that of a principal and a commission vendor. Full stop. As per the such inter se relationship of principal dash vendor, comma, a commission vendor shall sell, sorry, the catering unit department, same, of the administration shall supply to the commission vendor the articles to be sold by him, and the commission vendor shall sell the same to the public traveling by trains at a specified place or places, and during the specified hours of day and stroke night at the rates fixed by the administration. The commission vendor shall not sell any articles or goods to the public traveling by the trains, save and except the articles supplied to him by the catering unit department of the administration. The tariff rates of articles are to be predominantly exhibited by the commission vendor at the place or places from where sales are accepted. Full stop. It is the administration who had undertaken to supply the requisite equipments to the commission vendor so as to enable the commission vendor to discharge the duties his duties and functions satisfactorily and efficiently, and the commission vendor is to be held responsible for any damage due to his negligence. Full stop. It is also inherent that if the in the letter dated 15/12/2006, it was specifically mentioned that if the petitioner as a commission vendor would be given the commission over the sales on eatable items at the prescribed rate circulated by the administration. Full stop. It was further provided that the petitioner would be directly under control and supervision of a prescribed, a designated official of the administration. And it would be open for the officials of the railway administration to make inspection and checking. Full stop. It was made clear that the sales proceeds had to be deposited to the designated official of the departmental catering unit at Guwahati. It was further made clear that the petitioner as a commission vendor would not derive any benefit like absorption as a regular employee, and his continuance as a commission vendor would not establish any claim for further engagement in the railway. Full stop. It was further laid down that any complaint from the public's members of the public or staff would result in termination of his engagement as a commission vendor. And the vendor, commission vendor license would be terminated on any date, could be terminated on any date without assigning any reason or without any prior notice. Full stop. Para. It is not in dispute that the stall located at platform number 6/7, 6/7 between Pillar 3-4 of the Guwahati railway station was a property and remained a property and remains a property of the respondent NF Railway. Full stop. As a commission vendor, the petitioner was only allowed to run the stall from the said location only and only on commission basis, without any other rights on the railway property, that is stall numbers, that is the departmental stall at platform number so and so between pillar number so and so. The inter-se arrangement between the parties herein, which is on commission basis, has clearly made the respondent NF Railway the principal and the petitioner on the other hand an agent, that is commission and agent, who is entrusted the specific task to run the stall and to earn commission. Para. The arrangement, para, the arrangement of a principal between which exists between a principal and a commission agent came to be considered by this court in WBC number 4430 2021 in the following manner. A. Para 14 dot D A para 15 থাকিব 15 থাকিব 15 এন্ডলৈ it has emerged without dispute. In the case in hand, it has emerged without dispute that the petitioner is only a commission vendor simpliciter without any kind of interest in the property in question, that is, the stall located at platform number 3/4 between pillar number so and so of the Guwahati railway station. The documents referred herein above and from the case papers, it has clearly emerged that by the impugned vacation notice, the petitioner was asked to vacate the departmental store. First off, it has further emerged that the petitioner has been granted an opportunity to relocate himself to one of the two alternative locations identified by the respondent railway authorities to run his business as a commission vendor. First off. Para. From the tender document of the NIT dated 9/8/2021, it has emerged that the responding railway authorities has fixed the reserve price of the SMU. Yes.
9 lakhs.
9 lakh. Per annum? Per annum. And the successful bidder would be allotted license to operate the SMU for a period of 5 years. Post on being awarded, the successful bidder as a licensee would be required to full stop na lage. Any indication about his revenue commission anywhere?
What he had done as a commission vendor in this petition.
Not there.
Percentage, am I aware of, my lord? For some items, it's 12%, as for some items, it's 6%.
It is not the case of the petitioner that the revenue amount sought to be earned by the respondent railway authorities by allotting the SMU at the same place could be anywhere near to the commission, the revenue generated from the earlier stall. Full stop. In the year 2017, the Railway Board, Ministry of Railways, Government of India, with an objective to provide quality food to the passengers of trains and to extend better catering service on trains, had envisaged the catering policy 2017 in supersession of earlier catering policies. Full stop. It was in pursuant to the catering policy 2017, the stall located at platform number so and so, between so and so, has been of the Guwahati railway station has been categorized as a SMU, means
Special minor unit.
special minor unit. As in the meantime, the Guwahati railway station has also been categorized as A1 class railway station. Full stop. The stall is undoubtedly a property of the respondent NF Railway. Full stop. The stand taken by the NF Railway authorities for initiating the tender process for awarding the SMU for provision of catering services is primarily for greater interest of the public and also to maximize revenue. As per the policy, catering policy 2017, so the decision of the NF Railway authorities to initiate the into an arrangement for a period of 5 years in pursuance of the said policy and to maximize the revenue cannot be said to be a decision taken against the public interest. Full stop. Even otherwise, the courts exercising the power of judicial review under Article 226 of the Constitution of India does not exercise any appellate power over the decision of an executive authority. Let him complete so that Mr. Sharma and Madam, let him complete tomorrow, not tomorrow, Thursday, 10:30.
It's almost complete.
Almost will say that I'll find out the distinction in other one, if anything.
Only distinction is that the license.
Let me look at myself.
Sorry.
Unless I get satisfied. Yes, Mr. Doctor, you are waiting something.
The interim order is there, that should be continued.
You okay? লিখে দিব হেৰি হাৰ্ট so and so. Madam, your name? AB Cast, and B Sharma লিখে দিব. List as the hearing is not completed, list the cases again on so and so as part of.
If Lordship permits, can I point out one thing? In Sanju Datta's case, there is one more difference. The stall has already been allotted, and that successful bidder.
I'll not remember. You be there. Mr. S. Dr. Learned Senior Counsel, assisted by Mr. S. Dr. Learned Counsel, but a petition is present. Post op. Due to paucity of time, the case could not be taken up today. Let the case be listed. You want any fixed date?
Any day convenient to you, Lord.
After 1 week, the interim order passed earlier shall continue till the next date of listing.
Obliged.
Wait. এইটো আপুনি ৰেকৰ্ডটো হেৰি কৰি থাৰ্ছডে কৰি দিব, এইটো যদি তেওঁ লিখিবৰ কাৰণে সুবিধা হয় এইটো কৰি দিব এৰেঞ্জমেণ্ট so that